Yes. Maybe. My lord, with consent of the other side, I beg to mention from item 20, my lord, to 27 series.
Why?
My lord, on behalf of the department, my lord, I need to file an affidavit, my lord.
Oh, we'll take it up. We'll see why the affidavit has not been filed till now. See.
Please, Your Lordship. Your Lordship, I beg to mention item number 29, Your Lordship. In this matter,
29?
29.
Why?
My Lord, we need to file our rejoinder in this matter. It's 2 weeks time.
You are APDCL?
No, my Lord, I am for the petitioner.
The request of the learned counsel for the petitioner matters that adjourned for 4 weeks.
May I please the Lordship, my Lord? I beg to mention item number 13, my Lord. 13, my Lord.
Don't like the number?
My Lord, in this matter, we have already filed one affidavit. There was some development. So regarding the latest development, we are directed to file another affidavit. The department has requested me for 3 weeks time, my Lord. So I pray for 3 weeks.
You've informed the other side?
Yes, my Lord. Petitioner is there.
Okay. At the request of Mr. DP Bora, the learned counsel appearing on behalf of the health department, 3 weeks time is granted to file after.
Deeply obliged, my Lord.
Deeply.
So for item number 28 is concerned, Lord, we take up with 2 Lord.
Which one?
Item 28.
Yes. Why?
It's a case of 22 Lord.
Huh? It's
Cases of
2022.
2022, even then, Lord.
Why? What are you asking for?
For upgradation.
Understood. Why? What is the matter for?
So the matter regarding non-payment of the amount which was due to the petitioner.
Okay, we'll update. Yes,
with
please.
regard to item number 69, 69 in supplementary list. Matter has become infructuous. The grievances has been addressed.
Okay, heard Mr. P.K. Munir, the learned counsel appearing on behalf of the petitioner who submits, who upon instruction submits that as the petitioner have got the relief as sought for in the writ petition, he does not want to press the writ petition. Accordingly, the petition stands closed as it has become infructuous.
Deeply open. Item number 19, Lord.
19?
19.
Yes.
I'm newly engaged counsel, Lord. I will file wakalat number, Lord.
Yeah, for respondent.
Petitioner, Lord. Petition.
Your name?
A. Sharma.
Your name is not shown.
No, I'm going to file wakalat number today, Lord.
Then?
Any date, Lord. Any short date, Lord.
Your name is not shown. How do you have not filed wakalatnama? How can I?
Today I will file, Lord.
Huh?
Today itself I will file. Today I received
I
the
am appealing for the respondent, my lord.
Understood, but you don't have locus today to make a mention also, unless you file your wakalatnama. Don't you think so? Tomorrow, this person, these persons whose names are listed out there, shown in the list, they come up. Who is he?
So far my information goes, Lord. His engaged counsel is in bedridden condition, Lord. Engaged counsel. That is why I am coming.
Okay, you say that. Then I can do it. At the request of the learned counsel, Mr.
A. Sharma.
A. Sharma matters who submits that that the counsel appearing on behalf of the petitioner is in bedridden condition. The matter stands adjourned for 4 weeks.
Obliged.
Well,
Yes, Mr. Manshi.
I beg to mention one item, my lord, that is not in the list. May come upon tomorrow, day after tomorrow, or next.
Why?
Admission matter, urgent matter, 2018 matter, my lord, regarding pension.
Oh, why do you want it tomorrow or day after? Why
Day
you
after
waited
next
for
week,
5
Second,
years?
third, fourth, your lordship.
We'll have it on 8th of May. 8th of
Maybe on 9th,
no,
10th, my
10th of May.
May I please, your lordship? Lordship, yesterday one hearing matter, lordship, fixed on 23/05/2023. Lordship, on that day, lordship, my seniority will be out of station, lordship. And
Who is
the
your
second
matter
question,
has come on yesterday.
yes, lordship.
That matter is not listed before this court now. Why will this court pass any order? Mention it on 23/5.
I'd like to mention item number 39 of today's list, my lord.
Yes, tell me.
With the consent of the other side, my lord, I want to take 1 week time for filing the affidavit, my lord.
You have for
For
animal husbandry.
husbandry.
Yes, MM Kutuki, the learned counsel appearing on behalf of the Animal Husbandry and Veterinary Department. Request for an accommodation for 3 weeks for filing an affidavit in opposition. Accordingly, let the matter be listed after 4 weeks.
Release item number 1 for motion.
Make this a lordship.
Yes, Mr.
Sorry, lordship, last occasion, lordship, my junior satisfied lordship.
Regarding,
Lordship, regarding it's a relating to the compensatory family pension or family pension, lordship, petitioner's son expired on lordship 2018, lordship.
you are
I am the mother,
the mother,
lordship,
compassionate family pension.
pension, lordship, because his date of birth as per service book, lordship, 36/1967. I have a copy of that, lordship, and importantly, lordship, I could not annex that part, lordship. If lordship kindly consider, or I should file an additional affidavit on that regarding the date of birth. I have
Anyways,
a copy of that.
Date of birth is not given here. On the
Lordship,
last occasion, I
Lordship,
asked
lordship.
to file an affidavit.
lordship.
Now,
I
when is he going to retire? Your son was supposed to retire.
supposed to retire on 2027 because his date of birth as per service book, lordship. For kind consideration, lordship, if necessary, I'll file additional affidavit 36/1967. And inadvertently, one annexure, lordship.
Now, your son is married to somebody?
No, lordship, that married, that wife expired, lordship, and another wife, lordship, all other financial benefit, because son is disabled, lordship, and daughter already got married, and only mother is surviving mother, and because of which, lordship, all other financial benefits regarding.
No. Are you saying your son did not have a wife at the time of his death?
No, lordship, one wife was there, but she left.
She left or
She
divorced?
left. One first wife died, second wife got married, lordship, but she left, lordship.
She left where?
Before his death, lordship.
How? Divorce?
No, lordship.
Then wouldn't she be entitled to?
No, lordship, she is as per the Gaubula certificate, lordship.
Ah.
Shows, lordship, I have got that, lordship.
Have you made her a party?
No, lordship.
Why?
I have not made party.
Why haven't you made her a party?
Lordship, because the question of.
How can this court adjudicate this issue without her if she is there?
With all respect,
Or you
lordship.
don't want to recognize her?
No, lordship. I am not on that, lordship.
You
Since the official
are
communication,
asking for a compassionate family pension.
lordship,
Compassionate family pension is you are also entitled, she is also entitled.
lordship.
Then why is she not made a party?
I pray, lordship, let the authority, lordship, because they are not considering as per pension rule, lordship, I am entitled, but they are saying that mother is not entitled. My case is that, lordship.
Isn't it your case of compassionate family pension?
I am on twofold prayer, lordship, either pension or compassionate family pension.
No, Mr. Counsel, is your case not coming within the ambit of the compassionate family pension for the time being? Because he's supposed to retire in 2027.
Lordship,
So obviously, and he died after 14/3/2017.
lordship,
When did he die?
died on, lordship, he died on, I have a copy of that, lordship, on 27/3/2018, lordship.
So he comes within the ambit of that.
Lordship,
Now, if he comes within the ambit of that, have you seen the compassionate family pension
Lordship,
of
I have annexed that.
14/7/2000?
lordship,
Kindly come to clause number 5.10.
lordship. I have annexed that also.
Very good. Have you looked into that clause? Now let us hear what is there mentioned.
100% of the last paid loan to the deceased employees he paid for a period up to the date of deemed superannuation.
Where is that?
Page 48, lordship.
Yes. 5.10.
5.3 I am reading, lordship.
5.10.
Lordship, 5.10.
You have not looked into this.
Lordship. It is also provided that if the parents or other eligible family members are not looked after by the compassionate family pension, on receipt of such complaint from them, the competent authority will issue orders appropriate to the compassionate family pension appropriately among the other eligible family members. Lordship. But Lordship, as per next in certificate as well as the others, Lordship, I have annexed that also.
Next of kin certificate, who have applied? You.
Lordship, it was, page 35, Lordship.
When?
It was.
Where is it?
It was into 3/8/2021.
Page.
Page 35, Lordship.
Page 35. Son and daughter is there?
Lordship.
Why haven't you made them parties?
Lordship, because daughter is already married, Lordship.
So?
Daughter is not entitled. As per pension rule, Lordship, she if the married daughter, I have annexed that also new rule, amended rule, in which, Lordship, the married daughter is not entitled as per pension rule 143, Lordship. And son is completely disabled, for which, Lordship, page 41, all financial grants of other area salary and others, Lordship, were granted to the present petitioner. Page 41 may kindly peruse, Lordship.
But what about the wife?
There,
Or you don't want to recognize her?
Lordship, as per the succession certificate as well as the next.
No. Succession certificate, you have gone before
Yes,
the deputy commissioner or whoever
Next
authority have got it
Lordship,
done.
Next in
And
certificate.
they have just given it just for the sake of it without looking into as to whether there is any other wife or not. Have you disclosed it that there is another wife?
Lordship,
Your husband, your son had?
Lordship, son died, Lordship, leaving one daughter, mother as well as son. One
Wife?
son,
Wife?
that wife, Lordship, is not there, Lordship,
Why?
because she was not staying with them, Lordship.
So, but has there been a divorce?
Lordship, that,
Today I directed the
I'm-
compassionate family pension to be paid to you.
Lordship,
Tomorrow,
let them verify,
she will come
Lordship.
up and file a review. Look here,
No,
I am the wife.
I am
and
not
this has
on that,
been me.
Lordship. I will not fail such things, Lordship.
Have you mentioned in your petition to the effect that there is another wife?
No, Lordship.
Why?
Because, Lordship, as per the records, Lordship, the next in
Oh,
certificate.
isn't it necessary, Mr. Modunda, to come up to a very fair
Let-
note out
let
there
me
that
file an
there was a
additional
wife? There has been no divorce.
Lordship, let me file an additional affidavit with.
How
all
many
documents.
additional affidavits you are going to file? You have already filed one. Now you want to file another one.
Lordship, only read petition we file. No
Huh?
additional affidavit filed. Lordship.
Didn't file that as regards her date of birth.
No, Lordship. Because of which I pray, Lordship, I will submit all the
Okay.
documents.
At the request of Mr. K.
One
Mudinda,
week
the
time,
learner
Lord.
the matter stands adjourned for 2 weeks. Within that state time, the petitioner is at liberty to file an additional affidavit.
Lordship.
Number 2.
Lordship, the matter pertains to provisional pension. Lordship, in the matter was last listed on 19th of April last week. Your Lordship was directed to place the appointment details of the petition on record, Your Lordship. We have filed the affidavit yesterday, Your Lordship, additional affidavit. However, it's not on record, Your Lordship. I have an
Miss, your name?
S. Sharma Hazare. S. Sharma Hazare.
S. Sharma
Hazare.
Hazarika submits that she has filed an additional affidavit in the matter. However, the same is not on record. Let the matter be listed again on 3rd of May 2023. On the registry is directed to tag along the said additional affidavit. You have given copies to them?
Yes.
My Lord, I have not received it.
Oh, you have not given it? Okay, you do that exercise. There's somebody waiting.
My name may be reflected in the list, otherwise I have to miss.
Ms. M.M. Kotoki appears on behalf of which department?
Animal husbandry and veterinary.
Animal Husbandry and Veterinary Department. The registry shall show her name in the court.
Number 3.
That is your Lord.
Yes,
This
Mr.
petition is against an order of suspension.
Hmm?
And against an order of suspension.
Suspension. Okay.
He
was placed under suspension on 4th of January 2023. The principal of the college, and there was an FIR.
Why were you suspended?
My lord, suspension order is at page 23, date, my lord, 4th of January 2023.
Page 23.
And effect is given.
In pursuance to a letter received from the president of so-and-so regarding arrest of so-and-so principal pending trial of so-and-so is placed under suspension. When were you arrested?
I was arrested on, my lord, 30th of December, my lord.
And when you came out?
I have come out on, my lord, bail granted on 9th of January 2020.
9th of. Have you informed them?
Yes, my lord. We have informed.
When
them.
did you inform?
The application, my lord, initially the petitioner informed on, my lord, 10th of January 2023.
Where is it?
That is at page 29.
Page 29.
And he also filed a representation on 23,
10th of
March.
January bail order you have informed. Okay. Then?
Now, my lord, till date, no charges.
You are still under suspension?
I am still under.
Your case is on Ajay Chaudhary? Mr. M.K. Chaudhary, Learned Senior Counsel, assisted by A.U. Ahmed. Mr.
Yes, that's my.
As does appears for which department?
1 and 2, my lord. Higher education.
Respondent numbers
1 and
1 and 2. Why not 3? 3 has no role.
no, lord. 3 will.
Why is the inspector of schools made a party?
My lord, may not be a necessary one.
1 and 2. Mr. M.K. Chaudhary, the Learned Senior Counsel, submits that for the purpose of the instant case, the presence of the respondent number 3 is not necessary. Taking into account the same, the name of the respondent number 3 is struck off. The registry shall make necessary correction in the records. Issue notice making it. When can you get it?
2 weeks, my lord.
Issue notice making it returnable on 12th of May 2023. As thus appears on behalf of the respondent number 1 and 2, extra copies of the petition be served upon him during the course of the day. The case of the petitioner herein is that the petitioner was arrested
In fact, my lord,
in connection with Barpeta PS case number 1058/2022 on 30/12/2022. In pursuant thereto, the petitioner was put under suspension by the Director of Higher Education in exercise of the powers under 6.2 of the Assam Service Bracket Discipline and Appeal Rules 1964. Subsequent thereto, on 9/1/2023, the petitioner was released on bail by the Judicial Magistrate, first class, second class, third class, which
first
one?
class, first class.
First class, Barpeta. This bail order was brought to the attention of the respondent authorities by the representation data, respondent director of the respondent number 2, that is the director of higher education, by the communication dated 10/1/2023. Subsequent thereto, the petitioner had submitted representations, but till date, neither the petitioner have been reinstated in terms with the proviso to Rule 6.2 of the Rules of 1964, nor the petitioner has yet been served any memorandum of charge of charge sheet, which is required to be given within a period of 90 days from the date of the order of suspension in terms with the judgment of the Supreme Court in the case of Ajay Kumar Chaudhary versus Union of India, reported in 2015, 7 SCC 291. The Learned Counsel appearing on behalf of the respondent number 1 and 2 is directed to apprise the court on the next date as to whether there has been compliance to the law declared by the Supreme Court in the case of Ajay Kumar Chaudhary Supra. Full stop. Liberty is given to the petitioner to mention the matter for upgrading on the next date.
Item number 4.
That an observation will be made that the parenthesis cannot be a part of
Mr. Chaudhary, I don't do that. Then why have you come? You have, if you still have a hope that they are going to do it.
on receipt or notice, my lord.
No, they don't do it. They will put a date on.
So we wait for the wait.
Yes.
This matter pertains to the payment of scale of pay.
Payment of
For payment of
salary.
Yes, lordship.
You are not entitled to the salary.
Salary, payment of salary. For
What is your case? Directing the petitioner the scale of pay payable to the deputy commissioner.
yes, sir.
You are a deputy commissioner.
Yes, sir.
Every concern got to mention corporation, my lord.
Huh?
Zone.
GMC.
They were GMC, my lord.
From the date he was entrusted as the duty in charge of the deputy commissioner. In charge.
In charge, and he won the
Similar order.
No. Somebody they keep on doing all these things. That's a different thing. But how are you entitled to on the basis of being in charge?
Lordship, earlier.
Similar orders are given, but you want I will distinguish it. But how can you be entitled to when you are appointed as in charge?
Lordship,
Is he entitled to?
Lordship,
Then tomorrow, not only this, every other case where the principal is being appointed or headmaster is being appointed in charge, then all this payment has to be made.
Lordship, actually what happened from 2013, they have not given promotion as such, and they are making all the posts of deputy commissioner managers in charge, Lordship. As such, Lordship, on last...
Then you challenge that.
Yes, Lordship, I have challenged.
But why you are not asking that you should be promoted?
No, Lordship, they are keeping the
Why
promotion on
haven't you
hold.
asked? Why there is no
They
prayer
do-
that you
they
should be
don't want to
considered for
influence
promotion?
again. Yes, Lordship, I'm coming on that.
No, you have not. This is not your prayer.
This is not my prayer, but
Then
Lordship, some other incumbents were allowed their charge, Lordship, salary on the basis of the mayor in council decision, approval of the mayor in council. Commissioner has given the scale, Lordship. And recently,
Madam, you just show me one document or any provision that if a person is appointed as in charge, he is entitled to the pay of the post. Show me that, I'll give it to you.
Recently, Lordship, mayor and council has approved the charges allowances from DC. At least that may be given, Lordship.
Charges allowance.
Yes, Lordship, for holding the post of deputy commissioner. Lordship. After filing of this petition, I got the mayor and council approval, Lordship.
You bring it on record. Why you are not
No,
bringing it?
Lordship, after filing of the...
Very well, bring it on record by way of filing an affidavit. You'll get it. When can you get to file it?
1 week, Lordship.
Huh?
1 week.
Okay. At the request of the Learned Council, the petition stands adjourned till 8th of May.
5.
Yes, Mr. Sharma.
Lordship, matter pertains to suspension as well as non-payment of subsistence allowance. Since there is a specific direction in the suspension order that petitioner has to be paid the subsistence allowance during the period of suspension, and the
When were you suspended?
on 3/6/1995, Lordship.
What?
1995.
1995.
Yes, Your Lordship.
And why you have today?
Lordship, no disciplinary proceeding has been initiated, Lordship, till date.
1995 he was suspended. Now he attained the age of superannuation. He is now 60 years old. Now he is before this court.
No. First of all, why have you kept him suspended for such a long time?
To that
Isn't
extent,
it in violation to your manual?
Lordship,
Then,
to that extent, I have to obtain instruction, Lordship.
my
Whether-
goodness, a person has been suspended for such a long time. And you have not been paid the subsistence allowance.
No, Lordship.
Where is your suspension order?
The suspension order is page number 25 is the, Lordship, type copy of the suspension order.
My goodness.
Page 16.
Heard Mr. D. Sharma, the Learned Counsel, appearing on behalf of the petitioner. Mr. P. N. Sharma appears on behalf of the respondent number 1,
all the
2,
respondents.
3, and 4. So issue notice making it returnable. Well, it is surprisingly When? 10th of May. Issue notice making it returnable on 10th of May. As respondent number 1 to 4 are duly represented by Mr. P. N. Sharma, extra copies of the writ petition be given to him during the course of the day. The case of the petitioner is that the petitioner was suspended on 3rd of June to 1995 by the Director of Elementary Education in exercise of the power under under Rule 6.1 of the Assam Service Discipline and Appeal Rules 1964. The Learning Council for the petitioner submits that the departmental proceedings have not yet been initiated. This aspect of the matter shocks and surprises this court, taking into account that almost 28 years have passed by, but till date, no departmental proceedings have been initiated, whereas the respondents continue to suspend the petitioner, as have been alleged in the writ petition. It has also been mentioned that the petitioner have not been paid the subsistence allowance, which the petitioner is otherwise entitled to in terms with FR 53 of the FRNSR applicable to the state of Assam. The Learned Counsel, appearing on behalf of the respondents, is directed to apprise this court as to whether there is any departmental proceedings initiated against the petitioner, and as to why the subsistence allowance, as claimed in the petition, have not been paid to the petitioner. Liberty is given to the petitioner to mention the matter for upgrading on the next date.
Highly obliged.
Number 6.
Yes, Mr. B. Chakraborty.
Lordship, this is matter relates to the transfer, Lordship.
Pension?
Lordship, transfer, Lordship.
Transfer.
Lordship, the government has framed a law under which the teachers can apply for the transfer under Section 10, Lordship. That will, Lordship, will find at page 45. I have annexed that, Lordship.
Yes.
Now,
That regulation.
Applications. It has to be applied online, Lordship.
Yes.
We have applied under this 6 conditions, Lordship. Transfer can be considered, Lordship. Now the matter is pending for NOC before the BTC authorities, Lordship. So let them take the instruction why it has been withheld, Lordship. Let them, Lordship, may issue notice at this stage. And
You want that as of now, when did you file the application?
Lordship.
You have to file online.
Online, Lordship.
When did you file it?
The acknowledgement received, I have a next, Lordship. Lordship, find it page 49, Lordship.
What is this page 49? Page 75?
No, Lordship, page 49. Annexure F1, Lord. It was filed on 8/11/22, Lordship.
Then
Lordship.
What is your ground?
Various ground, Lordship, each of the teachers.
Understood. What is your ground? You have so many ground. Give me one of the 8 A2F.
Lordship, I have simplified for easy understanding in paragraph, Lordship.
You are not aware.
Paragraph 8, Lordship.
You are not aware.
Paragraph 8.
No, we have 6 grounds. You are not aware which
9
ground will
teachers.
come within it.
Now 9 teachers are on different ground, Lordship.
On 9 teachers? Why?
So from the same DO.
My goodness, this court is not going to entertain this petition.
Lordship.
This can't be a same cause of action in any manner. Then how 9 petitioners' applications are you are filing and together?
From the same district to the same.
No. Everybody must be having a different ground.
Lordship, ground
Then-
is different, Lordship.
Then withdraw. File separate with petitions.
So then, Lordship, this may be pursued in respect of respondent petitioner number 1. Rest of them I am withdrawing, Lord.
Okay.
File fresh.
You are withdrawing the others?
Others, Lordship.
Enter.
That's the
Liberty?
liberty with liberty.
And now tell me for one.
One is medical ground of mother, Lordship.
Medical ground of your mother.
Lord.
Very well. Now medical, what has happened to her? You have enclosed the medical certificate,
Lordship,
actually.
Lordship.
Where is it?
Page 50, Lordship.
Page 50.
Lordship.
Yes,
medical board certificate.
yes. Treatment, LGBT and mental health. Jamuna Neptune. She had last attended OPT in treatment.
And the treatment certificate is at page 51, Lordship.
Then, when you were posted there in this particular, which
From the very-
district you were?
From the very beginning, from the date of appointment, Lordship.
No, no, which district?
I'm in Dhubri district, Lordship.
Dhubri. And where do you want to come?
Udalguri.
You want to go to Udalguri?
Baksa, Lordship. Sorry, Baksa.
You from Dhubri, you want to go to Baksa.
Baksa.
And the treatment is done out here in Guwahati. Or Tezpur.
Tezpur, Lordship.
Then, and this treatment is going from 1985.
Lordship.
Then how do you get that it is necessary from this certificate?
Lordship, he has to look after his mother, Lordship. There's none other than Lordship.
And when were you appointed in that service?
We are appointed, Lordship, in 2016, Lord.
2016.
16.
So wait for another 4 years, then you get the benefit of this 10 years business. This document is not encouraging because your mother has been in treatment from 1985. You have to show something that yes, for this it is required.
Lordship 10B says, Lordship, for
Huh?
looking after elderly and ailing parents.
Understood.
Lordship.
Elderly parents. But ailing parents, if we come within the ailing, this treatment certificate cannot be the ailing because she has been in same treatment from 1985. This one. Now, what is the age of your mother?
Uh, 53 years, Lord.
Huh?
53. It isn't, yes, 53. Lord.
53. Oh, only 3 years older than me. Then, not necessary. Even he's not a senior citizen.
No, that's true, not citizen, but but suffering from mental illness, no.
This was there from 1985. Then,
We don't. We do.
Mr. Chakravarti, only one thing. This court does not like to be treated as a post box.
But under the act, I'm entitled to be considered. They may reject it or accept it.
Absolutely. If you are entitled to, you have filed it, they will consider.
Yes, Lordship. That is the minimum.
Why do you want this court's direction for that?
Because it is pending since Lordship. I have applied.
When did you file your representation again? Thereafter, have you filed a representation?
Lordship.
When?
Lordship, my application has been forwarded by the block element at page 78, Lordship.
No, understood. The block elementary education department have already done that
Lordship.
to the district elementary education officer. They have done it. Now thereafter,
Nothing has been happened, Lordship.
no, when there is a separate act out there, doesn't the act stipulate a particular period within which it is to be considered? When doesn't the rule say anything about this?
Nothing.
You have a rules also. Yeah.
Let him file a fresh, my lord, will consider it.
Pending.
Representation. A fresh representation.
No, representation, he has already filed it.
Already
The
filed.
number is already given.
Let's do on January, forwarded on 25th January.
Huh?
Forwarded on 25th January 2020. We'll consider and file past necessary order. That's part.
What is the number? Number of your application?
This is petitioner number 1.
Page Page, your application number. Where is your application?
9%.
Page 67? No.
9%.
Page 59. We are only considering one. Which one? What is the name of the petitioner? Let us see.
Page 77 is the forwarding.
Page Sarvananda Neptune.
New
Pani.
Page?
Page 77 is the director of
This was
education.
page 49. Page 49. Page 49 is your application.
Lordship.
Will pass orders.
Lordship.
Mr. Bora?
Lordship.
Will pass orders. Heard Mr. B. Chakraborty, the learned counsel appearing on behalf of the petitioner. On behalf of the petitioners. Mr. My goodness, how many people have you made partners?
1, 2, 9, 1 and 3. 1, 3.
Okay. Mr. P.N. Sharma appears on behalf of the Education Department. And Mr. S. Bora appears on behalf of the PTC. Okay. At the outset, this court put a query upon the learned counsel for the petitioner as to how 9 petitioners can together file a single writ petition seeking transfer from their respective posts as the cause of action in respect of each of the petitioners are completely distinct and different. The learned counsel appearing on behalf of the petitioner submitted that taking into account that the cause of action of each of the petitioners are distinct and different, the instant writ petition be treated as a writ petition filed by the petitioner number 1, and liberty may be given as regards the other writ petitioners to ventilate their grievances by way of appropriate writ petition, if so advised. Taking into account the same, the names of the respondent petitioner numbers 2 to 9 are struck off. The learned counsel appearing on behalf of the petitioner are struck off, with a further liberty being given to the said petitioners to approach the appropriate forum to seek appropriate remedies as envisaged under law. The case of the petitioner herein is that the case of the petitioner number 1 herein is that the petitioner's mother is, the petitioner is presently, where are you?
Lordship. At Dhubri, Lordship.
Dhubri where? School?
1514 number.
He is presently a teacher
Page 8, page 8, Lordship.
in a school by the name of 1514 number AIRMARI LP school. On account of the ailment of his mother, the petitioner sought for transfer where is Baksa? Baksa will be?
Baksa is the district, Lordship. Musalpur, headquarters.
No, where will be Baksa? Exactly.
It will be under BTC.
Tamalpur.
Huh?
It will be under BTC.
Baksa is here.
Tamalpur, near Tamalpur.
You are not asking for Udalguri.
No, Baksa.
But the treatment is in Tezpur. Then how does it have any relation out there?
I'll be with my mother all the days, Lordship, during
Huh?
at least I'll be able to control her.
How?
Staying with
Why you are not asking for Udalguri? Understood. You may ask for Tezpur because if you see, the right under section 10 for filing is to the home district or to a nearby
Home
district.
district is Pakistan, Lord.
Your home is Maksa. Okay. For transfer to his home district, that is in the district of Baksa. In that regard, the petitioner have filed an application in the online mode bearing number INTER-EE-002-001-2024 on 8/11/2022. It is the further case of the petitioner that the block elementary education officer had also given its no objection on 25/1/2023, but till date, the respondents have not acted upon the said application for which the instant writ petition has been filed. Mr. Esbora, appearing on behalf of the BTC. How can he pass an order? Can you pass an order?
Lordship is pending for NOC to be issued by them, by the BTC. As per notification, Lordship, page annexure E, Lordship.
The learned counsel appearing on behalf of the petitioner further submits that it is on account of the non-issuance of the NOC by the BTC. There has been the delay in consideration of his application. The learned counsel appearing on behalf of Mr. Esbora, the learned counsel appearing on behalf of the BTC submits that the instant writ petition can be disposed of with a direction to the respondent, BTC, to pass any order appropriate, to pass appropriate orders.
Particularly, my secretary will pass because page number 77 makes it clear. My
Secretary of what?
Secretary of Education Department, BTC. If Lordship turns to page number 77, because the director of BTC has forwarded it to the secretary. 77.
Submits that the Secretary Education Department Boroland Territorial can be disposed of with the direction upon the Secretary Education Department Boroland Territorial Council to consider the application of the petitioner and pass appropriate orders as regards the issuance of the NOC for transfer. Taking into account the limited grievances of the petitioner, and upon hearing Mr. Esbora, the learned counsel appearing on BTC, the instant writ petition stands disposed of with the direction to the Secretary Education Department, BTC, Ukraja, to consider the application of the petitioner and pass appropriate orders for issuance of the NOC for transfer if deemed fit. The said be done within a period of 1 month from the date a certified copy of this order is served upon the Secretary, Education Department, BTC.
Seventh,
Yes, Mr. Chaudhary.
Lordship, second round of litigation before your lordships. The husband of the petitioner was working as an assistant executive engineer, and while in service, he met with an accident and has thereafter acquired disability to 100% extent, your lordships. They were the authorities in the government of Assam, in the public health engineering department, were not releasing his salaries, and therefore the petitioner's wife had approached this honorable court by way of an earlier writ petition, which I'll take your lordships at page 89 of the writ petition. The order is annexed at page, it starts at page 89.
90%.
The effective portion is at page 91, your lordship.
Your husband is alive?
Yes, he's alive. 100% disabled. Your Lordship.
He's 100% disabled.
Locomotor plus mental. He has lost his cognitive abilities, Your Lordship. It was a subdural hemorrhage which he has suffered. And therefore, what has happened is that he has completely lost his cognitive abilities. And that certificate has been certified now by them at page 106. I have annexed. Pursuant to the.
And when was the accident?
Accident was in 2016, Your Lordship.
19.
No, 19, Your Lordship. I apologize.
You are asking for the area salary for this period?
Yes, Your Lordship. They have released some amount. The total approximate amount is about 36 lakhs, of which approximately 10 lakhs has been given interminably to me. And the rest they have just withheld and they're not doing anything about the matter. So I've been trying to approach them that give the the balance salaries in the arrears, and then they referred the entire matter.
But you say that 10 lakhs have been paid, but why are you asking for the mandamus for 36 lakhs?
Lordship, I think that was a slight typographical error because Lordship, that may be a mistake on my part. I do believe I had written 26.
Don't you want to file an additional affidavit making it clear, because otherwise wouldn't it be proper?
In my petition, I have made that clear. In the prayer, there was some small mistake. Lordship.
Where we stated that you have received 10 lakhs?
Lordships, I'll just page 12, Your Lordships, paragraph 11.
Page 12. Yes.
That the petitioner humbly begs to state that from the month of March
The
2009.
authority have already disbursed 10 lakhs.
Lordships.
Now, what do you want?
Lordships, I'm asking for a revocation of the last order, page 111, if Your Lordships will see. They have now issued another order in respect of my husband, saying that I should be given, if I may be allowed to read, Your Lordships.
So, why you are challenging this?
Lordships,
Are you not entitled to invalid pension?
In Lordships, invalid pension will be applicable only if I may just take Your Lordship to the invalid pension clause, Your Lordship. That clause is applicable to persons who have superannuated. I have not superannuated, and besides which, it is a rule of 1969. The Right to Persons with Disabilities Act is of 2016. Lordship, the law is very clear on that. I have a judgment of the Supreme Court as well, that in case there is a special law and there's a conflict between a special law and a general law, how the courts are going to interpret it. Now, this being a very special provision for persons with disabilities, that particular aspect has been considered insofar as Rule 38 of the CCS pension rules, which is almost, I wouldn't use the term parimateria, but yes, the language of the term is similar for central government employees of invalid pension. Rule 38 of the CCS pension rules. And here we're talking about Rule 82 of the Assam government pension rules, Your Lordship. Now, insofar as that is concerned, the Honorable Apex Court has very categorically held that it has to be the Right of Persons with Disabilities Act which will be applicable, and you cannot, they cannot take away my services or my salaries by giving me that invalid pension, especially when I was already holding that post. I have not superannuated. How can they apply the invalid pension? The rule itself is, if Your Lordship will read.
When were you supposed to retire?
Lordship, I am 52 years old right now, if I'm not mistaken. So I should have been entitled to at least 6 more years. He was 52 years old. He was 52 when he met with the accident. He would perhaps be about 55 now, Your Lordships.
Let's see what Assam government invalid pension.
I have quoted that rule in the petition, Your Lordships, although I have not annexed it, but it is quoted at page 23.
Invalid pension is where?
Lordship, section 3. It's at page in the book which I am carrying. It's at page 41, Your Lordships.
We are concerned with Assam?
Yes, Your Lordship. Yes. Assam Services Pension Manual.
Invalid pension?
It is section chapter 5, Your Lordships, of the Assam Services Pension Rules, 1969. Chapter 5, section 3. Lordships, page 41 of the book that I am holding.
Why are you holding that old book?
Lordships.
In one case, maybe. Chapter 5. Condition of grant of petition. You are into chapter 5.
Yes, your lordship.
Yes, invalid pension.
Invalid pension.
Section 3.
Rule 82, your lordship.
Compensation pension. Yes, an invalid pension is awarded on his retirement from Yes.
Now, if I may take your lordship to Rule 20 of the Persons with Disabilities Act for a moment.
No, we will go into that. But what do you say about 83, Rule 83?
This will apply only if the medical certificate is required. And in any case, by
No.
lordship-
This medical certificate is normally required. But if a person reaches the age of 60,
years.
then it is not required.
Yes.
Meaning thereby the invalid pension can be there in a case of a person who is prior to the age of superannuation.
Lordship, in my humble understanding, even if we apply Rule 83 for a moment, the medical certificate itself says that I am 100% disabled, both mentally as well as physically. Now, there is a new law which has come into force in 2016, which categorically states that there can be no discrimination in employment insofar as any person is concerned, your lordship. They cannot take away, they cannot dispense with or reduce in rank, or they cannot take away my service.
Where does it say?
Lordship, Section 20.
Of person with
right to
disability,
person with-
95 Act.
No, 2016. year.
You can-
95 also had the same provision under Section 47. your lordship.
2016 Act.
2016 Act.
You can repeal it. Right.
Lordship, I have quoted that particular provision also, in case you lordship want to read it for the time being. It is at page 23 of the writ petition.
Yes.
Now, you know,
Which clause you are
this
referring to?
second proviso, 24, Section 20, Clause 4. Page 14 of the act of this new act. your lordship. Oh, in the writ petition, it is page 23. your lordship. Second paragraph. No government establishment shall dispense with or reduce in rank an employee who acquires a disability during his or her service, provided that if an employee after acquiring disability is not suitable for the post he was holding, shall be shifted to some other post with the same pay scale and service benefits. Provided further that if it is not possible to adjust the employee against any post, he may be kept on a supernumerary post until a suitable post is available, or he attains the age of superannuation, whichever is earlier.
So you mean to say that a person concerned, even if he is 100% disabled, he can be continued to remain in the post?
Yes, Your Honor. There is a the ethics code 2004. This aspect of the matter was considered in the year 2004 when the earlier act was in force, lordships, and under the earlier act, section 47 was the provision almost similar, that a person's rank and post could not have been dispensed with. That was considered in 2008, 2004, 2004. 2003, sorry, 2003, 4 SCC, page 5 through 4, Kunal Singh, your lordships. In the
Because you see, after the 14.7 to a compassionate family pension, Mr. Gogoi,
My lord.
the compassionate family pension which is given,
My
requiring the same amount of salary,
My lord.
which will also accrue upon death as well as for permanent disability. That is there after 14.7. But this person had died, happened only on 2016.
19 years.
Oh, 19. Then why is he not entitled to compassionate family pension?
And Lordship, the endorsement has come from some other department.
It's okay. But why is he not entitled to under the compassionate family pension on 14.7.2017? Is there a case of not only death, a permanent disability also?
Yes, my lord. That notification, my lord.
Then,
I need to take instruction. And
madam, have you looked into that?
Lordship, I actually have not yet.
Oh, because there you get it.
Yes.
If you get it, then why you are going into all this running around with
I have been
this
running
person
around
with
from pillar to post,
disability?
and the second round of litigation, Lordship. The first round was very clear that the only liberty which was given to them was to take a note of whether actually my disability is 100% or not, which they have done. It is their medical.
No, when
code.
they
I
have
appealed
now a
twice.
policy, why the same has not been? Now you will be continue to keep on getting the same salary which you were receiving along with your DA and all till the date of superannuation.
My lord.
And thereupon, it will be for future period. I think that is also applicable, that case of family pension. Hey, item number 1 to the file. Item number 1 of file. Item number 1 has that office
Yes, my
memorandum.
lord. Under last page. Anyone.
In fact, Lordship, this entire spectrum of cases are also being considered by the Honorable Apex Court, and the government of Assam in particular departments have also issued an office memorandum saying that Section 20 should be complied with in its entirety.
My lord. Died in harness is the sole criteria. My lord. 5.2, my lord. It doesn't speak of physical disability.
So it is
Only criteria is, my lord, death in harness, my lord.
In the earlier one, it was there. No? Okay, no, it is not here. Okay. Heard Miss R.H. Chaudhary, the learned counsel, appearing on behalf of the petitioner. Mr. D. Gogo appears on behalf of the respondent number 1, 2, 3, 4. Mr. Ms. S. Sharma appears on behalf of the respondent
9, 10,
number
and 11.
Huh?
9, 10, and 11.
5.
9.
No, 9, 10, and 11. 12? No.
12.
Lordship, in 12, there is a
Mr. J.K. Goswami appears for respondent number 6. 8? 8, Lordship. And 12. 12. Mr. R. Bopudari appears for respondent number 7. Everybody is complete. Issue notice making it returnable on how much time?
3 weeks, my lord. It's PH.
Issue notice making it returnable on 22nd of May 2023. case of the petitioner herein is that her husband met with an unfortunate event, accident in the year, in the month of, when did you have the accident? February?
Lordship, on
February
24/6/2019.
24?
6/2019.
24/6/2019. It is the further case of the petitioner that the petitioner, that the husband of the petitioner, present age is 52, and he is supposed to retire in normal course. He was supposed to retire in normal course in the year. Yes, madam.
That is, I have not stated in my report.
What is your age of retirement?
58, if I'm not mistaken.
60.
50.
60. All government is 60.
60 then.
60. Then another 8 years more
Another 8
from
years.
today. Today is 52. That you are sure?
Yes, you. That time.
Around 2031. However, the respondent authorities, without taking note of the provisions of section 20, 24 or 20,
20 clause 4.
without taking note of the provisions of section
Section
20 bracket 4 of the Right of Persons with Disabilities Act 2016, have passed an order to the effect that the petitioner would be given, that the husband of the petitioner would be given invalid pension. Therefore, the order dated 23/2023 has been put to challenge in the instant proceedings. It is the further case of the petitioner that as of now the petitioner is entitled to an amount of rupees 36 lakh. Where is the page?
Page 12, Your Honor.
36 lakhs 2,145, and out of that only an amount of rupees 10 lakh 21,326 have been paid. The remaining amount is required to be paid to the petitioner, to the husband of the petitioner, which have not been paid. It is under such circumstances the instant petition has been filed. The learned counsel appearing on behalf of public health engineering shall obtain instructions as regards the order dated
For a moment,
23/2023.
23, my lord, reflects, my lord, this is a secretary to the government of Assam, my lord, ARTPPG, my lord, this department. It is on his views, my lord, this order has been passed. Administrative reform
You
and
have
training,
passed
my
the
lord.
order, Government of Assam Public Health Engineering.
PK Das, my lord,
Instruction here.
he has, my lord, if my lord goes to the body of the letter, my lord, secretary of the government of Assam, ARTPPG, my lord.
Yes, Your Lordship, and that's why he has been made a party respondent number 12 in the instant petition. I do not know, this communication has never been forwarded to me, and their internal.
Which one?
Lordship,
111?
111,
Yes,
my
page
lord.
111.
Assam administrative training and, my lord,
If
this
your Lordship sees a reference,
Where? Oh, this one.
page
And I to
reference.
inform you that the secretary to the government so and so has advised to act as per rule.
Lordship.
The respondent PhD department as well as Mr. J.K. Gusami, the learned counsel appearing for the respondent number 12 shall obtain instruction as regards the order dated 23/2023, and as to whether the said order is in conflict to the provisions of section 20 bracket 4 of the Person with Disabilities Act 2016. The learned counsel for the PhD department shall also apprise this court as to why the petitioner have not received the remaining part of rupees 26 lakhs, the remaining part of the amount after remaining part of rupees 36 lakhs 2,145 after the initial disbursal of rupees 10 lakh 21,326. Liberty is given to the petitioner to mention the matter for upgrade.
One small typographical error, Your Lordship. It is corner number 12. It should have read public pensions, public grievance department also. Can I just make that correction?
What?
There is corner number 12, Your Lordship. the whole, it is called Administrative Reforms, Training, Pension and Public Grievance Department. The word pension and public grievance by some mistake has not been typed in the body of the petition as respondent number 12. That
You
correction.
have made many mistakes. Is there? We will help you.
I'm deeply obliged.
8,
Yes, Mr. Ganguly.
May
We
please.
don't see you here nowadays.
Hi, Doctor. This is a claim for family pension by the widow, my lords. And what has happened in this case is that there was a marriage between the deceased and this petitioner under the Special Marriage Act. Page 12 is the marriage
The
certificate.
family pension and other benefits on account of the death of Imran Hussain conduct.
No, we were married, my lords, in 2015 under
Directing
the
and
Special Marriage Act.
inquiry into the proceeding against- What is this matter about?
No, this matter, my lords, is about the denial of family pension. My lords, I have applied for family pension, being the widow, my lords. What has happened is that the respondent.
Who are you?
I am the wife of late Imran Hussain Kandakar.
And who is respondent number 6?
Respondent number 6, my lord, is a Qazi, my lord, who has issued a divorce certificate under the Muslim law, my lord, at the instance of the respondent number 5, who is my mother-in-law. And on the basis, because we have not got any official letter of denial, on the basis of this document, it appears.
But how can you challenge this? Have you
No,
challenged it?
I'm not really challenging.
Then
it.
why you are making respondent number 6 a party?
No, because this person,
How can this court decide this as to whether the document is fraud or not?
no, my lord, as far as this document is concerned, my lord, my humble submission is that this document is not even relevant to my claim for pension.
Then why you are making it irrelevant?
It has been struck up, my lord. I have made you a party.
No,
he's
because
issued
you
this
are
document.
now creating the issue, the problem that if there is a divorce, where is your entitlement?
No, my lord, what has happened is this, that I have submitted all my documents. Page 34, my lord, I have given all the documents. I have given the special. They do not deny my status as a wife. But on the basis of this document, because I have not been given any official letter of denial, it is up to them to clarify the position. I have been only verbally informed that this document has been submitted by my mother-in-law, my lord, regarding my divorce. Whereas we were married under the Special Marriage Act, and my husband had even filed a divorce petition, which was closed because of his death. My lord. So, my lord, under the circumstances, the claim for family pension cannot be denied on the basis of this document at all, because we were never married under the Muslim law. We were married under the Special Marriage. And because of that only, my lord, the husband had filed a divorce petition under section 27(1)(b) of the Special Marriage Act, which was pending in the family court at the time of his death.
When did your husband expire?
Husband expired, my lord, on 30th of March 2022.
During the he was in
Yes.
service?
No, he had superannuated in 2018, 31st of December 2018.
So he was around, he
was drawing
died at the age of 64?
Yes, at the age of 60. And
64, 65. Yes.
yeah. And, my lord, the decree of dissolution was never passed because the proceedings, my lord, were
But
not
if
used to-
you are bringing that issue,
No, I'm not bringing, my lord.
issue a writ of
This
manner
document is-
directing the appropriate to and make an inquiry and proceeding against respondent for issuing a purported divorce certificate dated at the instance of respondent number 5.
If this document be,
Now, how can this court decide that?
no, my lord, this court need not even go into the issue. Let them
Why
clarify.
you are
my lord.
making it an issue?
My lord, let them clarify. Let them take whether this is the document.
Isn't it,
Because
Mr.
there is no other, my lord,
Isn't he raising the issue? I have not raised the issue.
we can, my lord, take back that issue. There is no, but this is the document given by them.
Understood, but if you have a certificate to that effect, you want to challenge the certificate, then how can this be the court which is the forum for that? Anyways, heard Mr. A. Ganguly, the learned counsel, appearing on behalf of the petitioner. Mr.
I'm for 1, 2, and 4, my lord.
Mr. TCCP appears on behalf of respondent number 1, 2, and 4. Mr. Nobody for Accountant General.
Accountant General, my lord.
Okay, none appears on behalf of the respondent number 3 on call. The learned counsel for the petitioner submits that the Office of the Accountant General have appointed certain counsels as standing counsels for the Office of the Accountant General. He may be given the liberty to serve a copy of the writ petition upon one of such counsels. You should notice making it returnable by 31st of May 2023. As Mr. T.C. Suti appears on behalf of the respondent number 1, 2, and 4, extra copies of the writ petition be given to him by 28th of April 2023. The petitioner is further given the liberty to serve an extra copy of the writ petition upon one of the counsels representing the Office of the Accountant General. By 28/4/2023. As regards the respondent number 5 and 6, steps be taken by way of registered as well as usual.
Whether perhaps notice not required as far as 6 is
Huh?
as far as 6 is concerned, perhaps notice may not be required.
Why?
Because
You want to, you have made him a part.
at this stage, perhaps
No. We'll issue
let
notice
it go.
by steps by registered as well as usual. The case of the petitioner herein is that the petitioner is the wife of late Imran Hussain Khandakar.
Perhaps she is the second wife.
And the petitioner is the second wife of late Imran Hussain Khandakar.
I remain.
And as such, the petitioner is entitled to. The first wife died?
No, divorce.
No,
Divorce.
that was not mentioned. Paragraph 2 only said earlier. Now let's see paragraph 2.
The certified copy of the family.
The petitioner is the legally made wife of late so and so, whose marriage was registered 15 before the office of the minister Kamrup Assam. And in respect of said marriage, the marriage was issued as so and so, so and so. It may be mentioned here that petitioner was previously married and she has 3 children in previous marriage, one of male so and so. And paragraph 3, Hussain was also previously married to one Saida Sultan. So she is the second wife.
Read the next line, the answer is there.
That is not.
It is the
explained
further
whether
case of
there
the
is-
petitioner that the husband of the petitioner initially married one Saira Sultana. And out of their wedlock, their 3 children were born, who are presently major. The said Saira Sultana was divorced by the husband of the petitioner prior to the marriage between the petitioner as well with her husband. Unfortunately, the husband of the petitioner expired on
30th March 2022.
30th of March 2022. The petitioner have applied for a family pension, but on account of some certificate issued by the respondent number 6, on account of some purported divorce certificate issued by the respondent number 6, dated 24/11/2021, the respondent authorities have denied the claim of the petitioner as she is denied the claim of the petitioner. The learned counsel appearing on behalf of the respondent numbers 1, 2, and 4, as well as the learned counsel appearing on behalf of the accountant general, is directed to apprise this court on the next returnable date as to why the petitioner have not been, why the family pension as regards the petitioner have not been issued, processed.
9.
I've given a date, 31st of May.
So he will provide an extra.
Yes, Mr. Saikya.
All these petitioners, they have retired from their service from the the 3 companies of the Astral ASCB between 1st January 2016 to 31st of March 2016.
7, they have retired.
In between 1/1/2016 to 31st of March 2016. Now, the pay commission, pay committee which was constituted, it had recommended after considering all the aspects, it had recommended for effective date as 1/1/2016.
16
1/1/2016.
for PTCL also.
Yes.
Where is it?
And now, while accepting the recommendation, the board in its meeting has considered as 1/4/2016 as an interim on the ground of avoiding the burden on the company, and a committee was constituted to evaluate the implication of if it is given with effect from 1/1/2016. That was constituted way back in 2018. But till that they have not submitted any report. So that is my case. If the as per the recommendation of the pay committee, if it is with effect from 1/1/2016, very few persons, including this petitioner, would have
No,
been
no. First, show me.
Yes.
This you are doing under the ROP 2017. You have the ROP of 2017 with you?
They have their own pay commission rules. This
No,
17 is
no.
also
I
an
think this
Not-
is
not
done
the
under.
state.
You are claiming under the Assam.
No. They have their own. They have their own pay committee. They constitute own pay committee. And
Then how are you entitled to?
because this pay committee recommends for all the three companies the revision of pay. And this committee is constituted by the board of the all the.
Now, when did the board apply the give the pay?
While accepting the recommendation, they have otherwise all the reports they have accepted. Only the effective date as an interim they have made 1/4/2016, and a committee was constituted by the committee by this board to evaluate the implication of implication of what would happen if it is made 1/1/2016.
No. From which time has these three companies given the ROP
Now in interim from 1/4/2016.
for everybody? 1/4. Now, why you have not got it
Because I have retired
prior to 1/4?
prior to 1/4.
So if it comes within the ambit of 1/1/2016 to 1/4,
Yes.
between 1/1 to 31/3,
Right.
then you will be given the benefit, isn't it?
The status of the committee, what they have done since 2008.
Mr. P.J. Soikia, Senior Counsel, assisted by Harish Mishra, Mr. S. Kotoki appears for which?
3 and 6.
3 and 6. On number 3 and 6. Mr.
P. Chaudhary, my lord.
P. Chaudhary
Number
for
1, 4, and 7.
1, 4, and 7. And
Our data for number 2 and 5.
issue notice making it returnable by how much time? Only to find out what has happened out there.
4 weeks, my lord. After 4 weeks.
No. 4 weeks will be when you want to contest. Here we are asking as to what has happened. You just let us know, and then if it's in their favor, not necessary. But if you have anything against them, obviously we'll ask you to file an affidavit. As of now, I'm not asking you. Issue notice making it returnable on 15th of May, 2023. As the respondents are duly represented by their respective counsels, extra copies of the petition be given during the course of the day. The case of the petitioners, who are 7 in number, is that the petitioners retired between the period from 1/1/2016 to 31/3/2016. The 3 companies who have been made the parties here in the instant, who are the party respondents to the instant petition, as an interim measure, have adopted the ROP.
Effective date of ROP.
ROP, which one? Assam.
2017. They have their own method. I have an
I have adopted their ROP.
ROP 2000.
of 2017 with effect from 1/4/2016. However, there has been a committee constituted to decide as to the exact date of when the ROP of 2017 would be applicable. The learned senior counsel appearing on behalf of the petitioner further submitted that in respect to all other aspects, the said committee have given their report. But however, there has been no report as regards the effective date for applicability for coming into effect of the ROP of 2017 by the state committee. It is the case of the petitioner that if the effective date comes within the ambit of between 1/1/2016 to 31/3/2016, the petitioner would be entitled to further benefits.
If it is
The
made,
learned counsel,
if it is made from 1/1/2016,
that is what 1/1/2016 to 31/3. Between
it
that,
will
no?
be 1/1/2016, not in between. If it is 1/1/2016, then
From-
all will be covered.
It's the case of the petitioner that if the pay scale, if the ROP 2017 is made applicable from 1/1/2016, the petitioner would be entitled to the benefits of the said ROP. Full stop. The learned counsel appearing on behalf of the respondents are directed to apprise this court on the next returnable date as to what is the status of the recommendations so made, recommendations sought for, and the recommendations pertaining to the ROP 2000 applicability of the ROP 2017 by the committee constituted. And as to whether the exact effective date have been given in the recommendation. Liberty is given to the petitioner to mention the matter for upgrade.
Item number 10 for admission.
Yes,
Yes, Manoj.
1811.
Yes, Manoj. 1811/20.
Yes. Yes, Mr. Khatri. Doctor.
Well, that's been given to me also.
You got a copy of it?
Yes, okay. We'll give it to you. this doesn't take into consideration one very important aspect of the rules method. Rule 3 method. So we kindly take up some second verification.
You have got this office memorandum?
Yes, sir. Yes, give me a copy by WhatsApp. Well, that doesn't take into account the rule 3. Where the rule 3 is specific to provision method.
I'm just coming in 5 minutes.
Fine.
19 of your petition.
Yes, for the petition. Sale number 6.
Yes.
Well, this amalgamation is without prejudice to the upgradation of scale of pay of teachers working in ME madrasas.
19, that is some 26th of December or something.
2006. That is the order of amalgamation. So this is at this point of time, this school was amalgamated with the following terms and conditions. Without prejudice to the upgradation of scale of pay of teachers working in ME madrasa intermediate scale of pay. So there is a provision that whoever were working in the intermediate scales, if they have the necessary qualification, they will be upgraded.
So the date of amalgamation is 27/11/2006. With effect from the date of amalgamation, you are therefore requested to take necessary steps for smooth functioning. Now we are concerning with the prejudice to upgradation scale of teachers of
working in ME madrasa
working in ME madrasa at intermediate stage of pay.
Now what I'm claiming, my lord, was that the earlier incumbent, my lord, he retired on, my lord. He superintended on 33/2011.
33/2011.
So my claim, my lord, comes from that date. From the day, my lord, the earlier, my lord, incumbent retired, my lord. My claim comes from that date, for that upgradation. Now this circular, first of all, came on 18th of November. So
27/6/2011 is the date.
27/11/2006 is the date of amalgamation.
11/2006 is the date of amalgamation.
And my lord, the Arabic teacher, my lord, assistant teacher, who was working in the middle high school, one Javed Ali, he retired on 33/2011 on the age of superannuation.
2011. Okay. Now your claim is from here.
Yes.
Okay. And now let us see which is the order.
This the order against by which my case was rejected. It comes at page 25.
This is page 25. Let us see. Perusal of the record is confined at Abdul Jalil. Abdul Jalil is you. You are Abdul Jalil. Okay. Referred to as the petitioner was appointed as a Arabic teacher in the intermediate scale. Proposal for upgradation of teachers working in intermediate scale of pay having degree qualification to the post of graduate teacher in higher secondary have been discontinued by the government by OM dated 20.
Well, this comes afterwards.
So it is on the basis of this.
Yes.
They have done it.
Yes. My claims, my lord, is from 3/11. Sorry, my lord, 33, my lord. 33/2011, 30th of March, when the earlier incumbent retired, my lord.
And this document has come on 18th of November.
With no retrospective effect being given. So it will be a case, my lord, where further proposals, my lord, after had the vacancy arrived.
When was the proposal sent?
My proposal was sent later on, my lord.
Then?
Well, even then, my lord, but since my claim arose earlier, it has to be given effect from that date, my lord.
How?
Because my lord, it is not been given retrospective effect, my lord. Further, my lord, if there is a new case, my lord, that will be effective. My lord. But this could not.
No, if your proposal has been sent after 2011,
that is there, my lord.
how is it possible to give it from 333 2011?
My lord, because my lord, it was the delay on their part, my lord. They ought to propose, my lord, process the proposal. Because my amalgamation was subject to that, my lord, that I'll be entitled to accreditation, my lord. But it cannot be changed, my lord. When this school was amalgamated, my lord, one of the conditions was that, my lord, although in the intermediate scale, my lord, will be without prejudice the rights to get the scale upgraded. So once the vacancy arose, my lord, it was their duty, my lord, to process the proposal and, my lord, get it done, my lord.
Is it your stand for that?
My lord, that because this was not given to me. This has come to me just now, my lord.
So that is not your stand.
That was not your stand, not my stand, because my lord, this circular was not given to me, my lord.
Then
this is only now, my lord, that has been given effect on, and there is no retrospective effect been given.
so your stand is that your case should have been given as on the date on which the vacancy arose.
Because that is my case.
But does it still remain the good law now?
My prayer, my lord, and in fact, my lord, this, my lord, the rule 7B2, my lord, that has also been, my lord, amended, my lord. That is no more there. That's a pre-amended rule, my lord. 7B2, which has been quoted, my lord, that is a pre-amended rule. That rule is no more there, my lord.
Let us see. Assam secondary education.
Provincialization, service schools 2003, my lord.
Where is that page?
370.
370. 371 is the relevant part. 7. Rule 7. Lordship, please see at the bottom, my lord. Substituted rule 7.
7 7-2.
7-2 B2, my lord. Before substitution. Read as.
So this was gone in the year 2012.
2012, my lord, was, my lord, withdrawn, my lord. It was, my lord, amended, my lord.
So after that, is there a scope of upgrading?
Well, my case was that, my lord, since, my lord, I was serving, my lord, now I cannot anyway be upgraded because I have retired, my lord. Only, my lord, that, my lord, that's the reason, my lord. In the similar case, my lord, they had, my lord, given instructions, my lord, that they will, my lord, give the pay, my lord. I have already retired, my lord. There's no question of, my lord, giving me the, my lord, upgradation anymore. But in this particular case, my lord, page 30, there's an order passed, my lord, on instructions from the government, my lord. And, my lord, my case is, my information is that this person has also, my lord, got the benefits, my lord.
Page 30.
Page 30, my
lord.
lord.
13.
30.
30. That was done in 2015.
15, my lord.
By the Learned Standing Council for a year, the question of granting graduate scale of fee to the petitioner does not arise in a the post shall have to be filled up by the This is a consensus judgment order.
All the instructions given by the department.
No, understood. The department has done that, but does Mr. Khatani have similar consensus? That is what he doesn't have.
Can from time to time, they have given to one person.
So there, at that point of time, it is there, but now he doesn't have that same thing. It is consensus.
Because my
can you apply this?
My lord,
and you missed the bus.
Provincialization was, my lord.
You missed the bus.
I missed the bus. I was made to miss the bus, man. I
no,
missed the bus, and my lord,
while you got this order done in 2015 at page 30, this petition is also of the year 2015.
My lord, there is another circular, my lord. My lord, page 27. My lord.
Page
27.
27.
Yes.
Yes.
So, my lord, I have made a specific statement, my lord. I'm serving as a, my lord, doing all the duties, my lord, of the in the upgraded, my lord, post.
So this is a circular which was there. For giving the benefit to intermediate.
Yes, my lord, because my lord,
You come within the intermediate.
I was intermediate, my lord, because but after my lord, the person retired, my lord. The incumbent was there, my lord. I have made a specific statement, my lord, all for all practical page 15, my lord. Sorry, page 7, paragraph 15.
Yes.
That for all practical purposes, the petitioner has been serving and rendering service as Arabic teacher in the graduate scale of pay in the amalgamated high school. Inasmuch as the petitioner has been teaching the higher classes in the retirement of the earlier incumbent. So, my lord, I have been discharging the duties of the my lord, the higher post. And so far, the rule 3 that was pointed out, of course, on a slightly different context, my lord. That, of course, speaks of, my lord, upgradation of the post, my lord. So, my lord, in terms of this circular also, my lord, 1995 circular, my lord, since I was, my lord, discharging the duties of, my lord, the assistant teacher Arabic, my lord, the graduate scale of pay, my lord, and teaching, my lord, higher classes also. So, my lord, I entitled the benefit, my lord, and this on this principle, my lord, perhaps this, my lord, was issued.
What is this FR 22182? Now, this is a notification. So you are claiming your benefit on the basis of the 7th of February 1995 notification?
This is one of the notifications I'm relying upon, and my particular case, is that since I was amalgamated with a particular provision, that I'll be without prejudice to my rights to get my pay upgraded. This was the terms and conditions of amalgamation, under which the amalgamation was done. And this particular scheme which was there adopted not to go for any further proposal, that came without any retrospective effect, it came much afterwards, because my claim starts from 33 2011. It has not been given retrospective effect. So that my submission will case cover cases which will have occurred where the vacancy arose after that particular case. Not prior proposals, because there is no retrospective effect given to that particular proposal. In other cases, similar cases, this person.
But that is not your case at all. What you are submitting now is not your case. Now, after looking into that particular notification, you have taken this stand.
Because my case, otherwise is for grant of
in fact, that is not applicable because the person concerned retired on 30/11/2011. Not 33/2011, by the way.
Which one? Javed Ali?
Javed Ali.
Oh, then matter ends there.
33/11.
Page 21, my lord.
Page 21. Then you don't have a case there. Yes. I retired on 30/11.
Yes, my lord.
That is your own document. Page 21. That is why in 2015 you didn't take up that plea.
Because,
and in fact, he was aware of this notification, my lord, because in the impugn order, copy was enclosed.
No. That I have specifically mentioned, madam. Paragraph 12. That copy was not given to me.
But he was aware of
Anyways,
it.
let us not go into those aspects.
Otherwise, also,
anyways,
my case would be even otherwise, since this is a case of my case was governed by the 2006 regulation, and sorry, 2006 order, where my case was amalgamated. And secondly, my lord,
But you are asking for a post on a date when that person has already retired only on 30/11/2011.
my case now is not for the post, my lord, only for the scale of pay, my lord, for the services I've rendered, my lord, under my lord, of that particular.
But that is against that, as per this new office memorandum.
My lord, that is with regard to my lord, upgradation of post, my lord, not with regard to my lord, grant of scale. The grant of scale of pay, my lord, therefore the department, my lord, in this particular case, my lord, said that, my lord, there is no objection, my lord, with regard to grant of scale.
Where?
This particular, my lord, page 30, my lord. Page 30, my lord.
Oh, that is being done by that consensus which has been given by Dell. That was his instruction. They have done it.
My lord, here also, my lord, I had sought, my lord, this, my lord, benefit, my lord. Then, my lord, they just said, my lord, they finally consider no.
How can I apply that if they don't give the consensus? Mr. Khatanya, you are ready to give. He is not.
But, my lord,
He's sternly opposed to it.
This person is getting all the benefits, my lord. Now, can they have a different stand from me? My lord?
The people get some benefit when the councils at that point of time thought it's something else. Can't help it. Nowadays, the councils for the government are very, what do you call it? The word is heartless.
Once this benefit was given, my lord, at the time of provincialization, my lord, amalgamation, my lord, can it be taken away, my lord, subsequently by notification? Because while the amalgamation was made, my lord, it was very clear, my lord, that I will be entitled, my lord, without prejudice to my rights to, my lord, get upgraded. Now, this by this
That order is your right to get the graduate is on the basis of an order, or is it on the basis of a statute?
My lord, the amalgamation, my lord, the problem is the amalgamation. There is no, my lord, provision in the statute. It was done as a matter of policy.
No, to get the operation,
my lord,
the graduate scale,
my lord,
is it based upon an order or is it based upon the statute?
It's based on the order, my lord, because amalgamation.
And why not by way of an executive instruction? It can be taken away.
My lord, but then, my lord, therefore, my lord, I'll be falling back, my lord, on this 95, my lord, circular, my lord, because I was discharging the duties of the assistant teacher, my lord, and my lord,
so you again come back to that document of 1995.
Then I have to come back to the document of 95.
Again. Okay. Now, what do you say, Mr. Khatuni, about this 95 document?
For that, my lord, I have to take instruction, my lord, because in fact, I am not aware of this notification earlier, my lord.
The whole matter.
Yes, my lord, I understand it.
Mr. M. Dr. the Learned Council appearing on behalf of the petition. Mr. N.J. Khatuni appears on behalf of the elementary. Secondary. In pursuance to the order dated 27/3/2023, the Learned Council appearing on behalf of the Secondary Education Department has produced the office memorandum dated 18/11/2011. The same is kept on record and marked the letter Y. From a perusal of the state document, it reveals that various proposals that were received by the department for upgradation of teachers working in intermediate course having degree qualification to the post of graduate teacher in higher secondary public high school. It was mentioned that the post of graduate teachers in higher secondary or high schools are filled up by the method of direct recruitment only under the provisions of Rule 8 of the Assam Secondary Education Provincialized Service Rules 2003. It was mentioned that there is no provision for upgradation of teachers appointed in lower cadre having degree qualification to the post of graduate teacher. Rule 7(2)(b)(2) bracket 2 bracket small b bracket Roman small Roman of the state rules of 2003 gives a preference to a graduate serving graduate teacher having a postgraduate degree for the post of a postgraduate teacher in that school. But there is no such preference in the case of intermediate teachers having graduate qualification. Accordingly, on the basis of the above, the government had decided that henceforth no proposal for upgradation of teachers having degree qualification and appointed in the intermediate scale of pay be submitted for consideration by the government. The learned counsel appearing on behalf of the petitioner submitted that there is a notification office memorandum dated, there's a notification dated 7th of February 1995 issued by the Deputy Secretary to the Government of Assam, whereby it was mentioned that in respect to upgraded pay scale of rupees 1185-2395 per month of assistant teacher, intermediate scale to rupees 1375-3375 per month in graduate scale for graduate incumbents. Fixation of pay in upgraded graduate pay scale would be regulated under the provisions of FR 22 small 22(1) bracket or small a bracket 2 of the FR and SR as applicable to the state of Assam. The learned counsel for the petitioner therefore submitted that on the basis of the said notification, the petitioner who have already retired ought to have been granted the graduate scale. The learned counsel appearing on behalf of the Secondary Education Department submits that he would like to take instructions in that state aspect. Taking into account that the merit petition pertains to the year 2015, this court fixes this matter on 2nd of May, on which date an attempt shall be made to dispose of the said petition.
Obliged.
Apply.
2nd of May is too early. We'll have it on 4th of May.
Can you be late?
Eh?
Can you some of it?
Okay, we'll have it on 3rd of May.
Item 12.
Yes. Who is appearing?
May I please, as your lordship?
Yes, what is your case?
My lord, my case is, my lord, regarding a notice has been challenged. But my lord, may be pleased to peruse the last order of 10/3/2023.
What are you asking for? You are
No,
suspended.
my lord, I am not asking that relief, my lord, but the this honorable
Set
court-
aside the impugned order dated 8/7/2019. What is it?
My lord, may be pleased to find is that
8/7 in
my lord.
8/7 in pursuant to the DME allowance dated so and so is hereby given 75%. You're
My lord.
challenging that?
At page 32, my lord.
Page 32. You have been given. You are
No, my lord,
Wahidur Rahman.
my lord, I am challenging this order, my lord, because what has happened, my lord, pursuant to this honorable court's order, my lord, this incumbent, Mr. So Wahidur Rahman, my lord, had been refrained from joining in my institution, my lord. And thereafter, my lord, the order of this honorable court, instead of being communicated to the respondent, my lord, the respondent has issued this order, my lord. As I did not follow the direction, therefore they have issued a show cause and wanted to initiate a departmental
No,
procedure.
the subsistence allowance is given to you. Why?
No, it is not given to me, my lord. It is given to the private respondent, my lord.
And why you are challenging?
I am challenging because I was the drawing and disbursing officer at that relevant period of time, my lord, as the in charge head mudaris of the institution, my lord. Now, what has happened, my lord, the private respondent number 5, my lord, was transferred from my institution to other institution, my lord, and he again reverted back to my institution. Then some of the guardian, my lord, whose words are studying in my school has put into challenge his reversion, my lord, and accordingly his reversion order was stayed by this honorable court. And my lord, during that development, the authorities has decided to give him 75% from our institution, my lord, which I cannot pursuant to the High Court order.
Who are you?
Lord, I am the head mother is at that relevant
You are
period
the
of time.
headmistress
Headmistress
of that school.
of that school.
Then?
Then, my lord, as I could not comply with this order of, my lord, this 8/7/2019, and then, my lord, this order at page 33 had been issued, my lord.
Because you have given the you were issued a show cause for not releasing the subsistence
Not
allowance.
releasing pursuant to the high this honorable court order, my lord.
Then?
Now, my lord, what has happened during, as this matter is a very old pending matter, my lord, there are certain developments are there, my lord. So that's why, my lord, I need some updated instruction that whether the present petitioner is still holding the post of in charge, because the school, the madrasa education, my lord, has already been abolished. It has been transformed into a school, and these schools, my lord, is now amalgamated with other schools also, my lord. So subsequent, I tried to contact, my lord, the petitioner, but, my lord, I could not. So I need some time, my lord, for the updated instruction, my lord.
What happened to your show cause?
My lord, it has been stayed in this proceeding, my lord.
Huh?
In the present case, it has been stayed by this honorable court.
The state?
Yes,
You
sir.
vacate the state? Then
Why
you
not?
will get the instruction. You
Why not?
immediately he will contact you.
My lord, day after tomorrow or Friday.
No, we'll vacate it. Until further orders, the personal appearance of Mr. Nayan, government of
No, my
Iman.
lord, actually, this matter was taken up on 10/3, my lord. On 10/3, this honorable court has taken otherwise, and, my lord, has the personal appearance was also called for.
For what?
My lord, for not filing the affidavit, my lord, in this matter, and then, my lord, a detailed order had been passed, asking the state government to, my lord, furnish certain instruction and status, my lord, of the.
No, Mr. Counsel, your case is that you were some headmistress of a
My
school.
case is not connected.
There was a
with-
direction passed
My lord.
whereby you were asked to give the subsistence allowance
My lord.
to a respond number 5 or 6.
My lord. 5.
You did not do so.
I did not do so because of the stay order operating, my lord, restraining that respondent from joining my institution.
So there was a stay.
There was a stay. My lord.
That is why you have done so.
That's why, my lord, he could not join and I could not pay. I intimated this development to the respondent. Respondents, my lord, without, my lord, complying with my intimation, this so-called had been issued me. That's why I came before my
Yes,
lord.
Mr. Katani.
Subsequently, my lord, he has released the substance allowance. I have received the instruction, my lord. In fact, my affidavit is also ready. On last occasion, supposed to file, but due to some reason, my lord, it was not filed. But affidavit is ready, and he released the substance allowance subsequently, my lord. After issuing the so-called notice, he has released the substance.
And what happened to the so-called?
Because, my lord, there is a stay operating in this case, my lord.
Now, how can there be a release of the subsistence allowance to a person where there is the order?
Subsequently, that person joined, my lord.
So that order has been vacated.
Yes, subsequently he joined, my lord. That's why I have received the
Not
instruction.
in
my
my
lord.
institution, in some other institution he joined.
So,
So if he has joined in some other institution, how can he release the subsistence allowance?
my lord, in my instruction, my lord, the subsistence allowance released by the respondent number 5 on 24/10/2019.
Now tell me, you were to file your affidavit and you, until further orders, the personal appearance have been dispensed with because you undertook to file the affidavit by 26/4.
Yes, my lord.
Now, why should this court not say that nothing doing? We want the, which is this, Narayan Kumar, Secretary to the Government of some Department of Education,
In fact, my lord,
before the court by tomorrow.
in fact, my lord, what I am submitting, my lord, on that day, the affidavit is prepared by me, my lord. In fact, I have drafted the affidavit and Mr. Gore, he has signed it also, my lord. But during that day, my lord, on 26/4, some other counsel appeared, my lord, before the court number 3. But why it was not filed, my lord, I am not aware, my lord. In fact, today morning I contacted with that counsel, my lord, but he could not give me the clear picture. Where is that affidavit, my lord? In fact, that has already been signed by Mr. Gore, my lord.
Today is what date?
Today is 26, my lord.
Today is 26.
Yes, on 3rd, it was affidavit was ready, and Mr. Kaur has signed it in court, my lord. In the court premises, he has signed the affidavit, my lord.
Then?
But why it was not filed?
Then I think the government of secretary should be aware that this is the lapses which have been committed by the advocate.
Yes, my lord.
So that is why we'll call him. You were supposed to file an affidavit.
Yes, my lord.
Then he has failed to do so. So we let him know that this is the state of affairs of your department. So he needs to amend things, change their counsels. Don't you think so?
Well,
when the court had dispensed with the appearance of the official only on the ground that there was an undertaking that you are going to file.
That affidavit, in fact, my lord, it was ready.
What happened to the show cause? If you have filed the affidavit, you have drafted the affidavit, then what happened to the show cause?
I have the
Understood, but what has happened to the show cause?
Show cause, my lord,
you initiated a show cause against the petitioner on the basis of not giving the subsistence allowance.
Yes.
Understood. Now he could not have, or he or she couldn't give the subsistence allowance because that person couldn't have joined by virtue of the order passed by this court.
Yes, my lord.
And how can there be a subsistence, the show cause notice issued? And you have drafted the petition.
No,
and you have challenged the show cause. Then what reply you have drafted? You tell me. You say that you have drafted. How could you have drafted without notice, without having knowledge? What happened to your show cause? That too.
That proceeding. After that show cause, nothing was done, my lord, because there is a stay of
have you dropped the show cause or not? How can you initiate a show cause where he is complying with the High Court's order?
That was a wrong done by the inspector of school. That was a wrong done by the inspector of school. But after that show cause,
we would do. I don't know, and we'll take it up at 2.
Yes, but I'll produce.
You get your instruction as regard the show cause. This show cause can't stand. And regarding the subsistence allowance to be paid or not, how can the payment of if there is a stay being passed by the court?
Yes, sir.
Find out what has happened to that order, Mr. Bhuya. You will find out that order. We'll take it up at 2. The matter shouldn't be there. Then looks like 2019 matter.
14. Item 14.
And trace out the affidavit who has filed it.
Yes, madam.
Or ask the secretary to be present on the next day when this court is going to pass order.
I'll find it out, my lord.
Yes. Mr. Soroni.
My lord. My lord, my learned friend Mr. Goswami, additional advocate, support to take instruction, my lord.
Lordship.
You have filed an affidavit?
Lordship, we have filed, Lordship, but in the last occasion, Lordship, Lordship sought for the present status of the petitioner's pension, Lordship. It appears that he regularly got the provisional pension, Lordship.
Provisional pension.
Yes, sir. He is getting.
After filing of this petition, not prior.
Oh, that matter.
Yes, Lord.
There's SBS, CBI.
Yes, Lord.
CBI, they got it out there. When are you giving him the pension and other pensionary benefits? Because he had no responsibility. The service book was recorded, seized by the CBI. And for that, he is not getting it.
I am not accused also in that case.
Huh?
I am not accused also in that case.
DCRG?
Yes.
When?
Lordship, I will submit the proper instruction.
Oh?
In the next day.
Proper instruction?
Yes.
1 month have gone by. I asked you to file an affidavit. You have filed an affidavit. No.
No, earlier we filed, Lordship.
No, then also, are you saying that
earlier,
this court's order is not required to be followed?
Yes, Lordship, earlier we filed an affidavit, but regarding the present status, Lordship, can you give me some time, Lordship, within 2 or 3 days, Lordship, I will submit the instructions as well as, Lordship, in the next week,
First
Lordship,
and
we submit the
foremost, why
affidavit,
he has not been, Mr. Sorani, have you got your DCRG?
No, my lord, except my lord, that provisional pension I'm not getting.
Why? He's nowhere accused in any case. Then isn't it the mandate of that office memorandum that and Rule 22 he should get his DCRG immediately?
I will submit the instruction, Lordship.
Instruction for what? You are supposed to file the affidavit.
Yes, I will file.
That to 1 month before.
I will file.
I've given time.
I will file.
When?
Next week, Lordship.
Yeah. We'll have it on
10. Second.
Next week.
Second. Yes.
My lord, may not be on second any other day.
You wait. Have I asked you, Mr. Sorani? I asked your junior to appear.
Lord, second. It may be.
File your affidavit.
Yes, Lord.
Not Mr. M. Soroni and the Learned Counsel appearing on behalf of the petitioner. Mr. J.K. Goswami appears on behalf of the respondent number 1, 3, and 4. Mr. R. Bopuzari appears on behalf of the respondent number 2. It has been brought to the attention of this court that the petitioner have now received the provisional pension. However, the petitioner have not received the DCRG, which the petitioner ought to have received, as submitted by the Learned Counsel for the petitioner. It also is relevant to take note of that on 29/3/2023, this court had directed the Learned Counsel appearing on behalf of the respondent numbers 1, 3, and 4 to file an affidavit. And for that purpose, almost a month plus time have been given for filing the affidavit. But till date, no such affidavit has been filed. However, Mr. Goswami submits that he is in the process of filing the said affidavit and shall file the said affidavit by 2nd of May without any fail. Taking into account, let the matter be listed again on 8th of May. In the meantime, the respondent 1, 3, and 4 shall file the affidavit by 2nd of May. In terms with the order dated 29/3/2006.
15 and 16.
Regarding to my lord, risk and hardship.
Oh, you paid the deficit court fee?
Yes.
Very good. Now, tell me.
My lord, matter pertaining to risk and hardship allowances to the petitioners, my lord.
Oh, that one?
Yes, my lord.
Hardship allowance?
Yes, my lord.
Then?
My lord, as per this honorable court order, my lord, 6/1/2023, my lord, they have to inform about the outcome of the process, my lord, of risk and hardship allowances. 6/1/2023.
6/1/2023. 23.
Yes.
6/1/2023. The respondents may inform this court about the outcome of the process that has been undertaken by the respondents for the risk and hardship allowances to the personnel of the CRPF. Yes.
Lordship, no decision has been taken.
Oh, they are not taking. They want.
Lordship may dispose if direct him to, since the matter is pending before them, to let them take the decision, Lordship, within a time frame.
Yes.
What? How? On what basis are you entitled to?
Yes, my lord.
Show me that.
Initially, they were granted. Lordship will find from the notification dated 19/2.
Where is it?
Oh, my lord. Is 100, my lord.
102, Lordship.
Office memorandum 31/7.
Lordship 22/2/2019. So
102.
initially Karbi Anglong was not included in this list. So later on, it was paid to them. Write another notification on
100 and my lord.
Risk and hardship allowance.
Yes.
You come. All these people are working in high altitude areas.
Yes, my. Yes, my.
And you are entitled to as per which one?
Yes, my lord. 100, my lord. Kindly, my lord.
100 or 102?
Sir, 1, my lord. Yes, my lord.
Yes.
100, my lord. That was 2017, my lord, office memorandum.
Okay, where?
Implementation of recommendation of 7th Central Pay Commission regarding grant of risk and hardship allowance to the personnel of CAPF and Assam Rifle.
What is this CAPF?
Yes, Central Armed Police Force.
CRPF and CAPF is same.
All this
Yes.
Lordship, Assam Rifle,
Yes, my
ITBP
Assam
and
Rifle.
all comes under this.
All
Central
are,
Armed Police
my lord.
Forces. The CIS,
Then why they have mentioned specifically Assam Rifles? If it is one and the same?
My lord. Then, my lord, here is, my lord, highly active field area. For highly active field area, they have, my lord, announced risk and hardship matrix, my lord.
So a person who is in high risk area would get an additional amount of rupees 25,000.
Yes, 25,000.
And level 8. What is level 8?
Yes, my lord. Level 8, here, my lord, category, my lord.
Huh?
Here, category, my lord.
And what is RH max?
Yes, my lord. Risk and hardship, my lord. High, medium, low hardship, my lord.
So the maximum amount a
yes.
person can get is 31,500.
Yes.
And maximum amount for grade A and below.
Yes, 21.
Grade A, 8.
21, 8 less than. We are, my lord. That, my lord.
What is your
2.
grade?
Yes, my pay is, my lord. They have initially, my lord, given us risk and hardship allowance in the rate of 7,649. Then, my lord, they have, my lord, as my annexer 6, my lord, that is approval order. They have given 9,700.
Okay.
Annexer 6, my lord. Now, my lord, what happened? They have stopped 9,700, but my lord, 7,649 was also stopped, my lord.
You are not getting 9,700.
No, now, my lord, no, not getting, my lord. They have given one point of time, my lord, 9,700. And this honorable court has, my lord, and recovery started. This honorable high court, my lord, stopped the recovery as per interim order, my lord.
Oh, you come under the medium one?
Yes, my lord. We are constable, my lord, general duty. Yes. Now, my lord, our company also fall under high risk, my lord, Hartfield area, my lord. I have annexed all the documents.
No, your claim is what, 9,700?
Yes, my lord, 9,700 also, and my lord, risk and hardship allowances. If my lord, they are agreed to 7,649, we also accept it.
You want less amount also, but you want some.
Now, my lord, their claim is, my lord, as per 2019, my lord, our company was not, my lord, in area, my lord. In before that, we are in that, my lord. In 2019, they had enhanced, my lord, 9,700 from 7,649 to 9,700. Then, my lord, they have said that this area is we are given wrongly. That they stop, my lord. Then we have filed this case, my lord, and this honorable court, my lord, recovery, my lord, that was stopped, my lord.
Why?
Yes, my lord. They have already given, my lord, an interim order passed, my lord, that recovery was not done, my lord.
No. Mr. B. Chakraborty.
Lordship.
Why have you initially given him some 7,000 something?
Lordship, we have to follow the notification dated 22/2/2019. That is annexure B.
Page?
200,
Yes,
likely to be
102.
211, Lordship.
Page 211.
If I'm not
That
wrong.
is your affidavit.
Lordship.
Okay. Now,
It is annexed in the writ petition also, Lordship.
No, signal.
In that page 28.
Okay.
Annexure B.
That is annexure 2.
Annexure
Yes,
2.
annexure
Annexure 2.
Page 102.
Lordship.
Okay,
So
now
in this
what do you want to
notification,
say?
Lordship, Karbi Anglong was not included.
Huh?
Karbi Anglong was not included because
Karbi Anglong.
Lordship will find the district concerning Assam is included at page, Lordship.
Yes, my lord. In this notification, Karbi Anglong was.
Wait. Let one person speak. Yes, where is it? In Assam. We will get it here. In Assam, Bihar, Chhattisgarh.
Assam, Lordship,
Assam.
page 222.
Assam, Arunachal Pradesh, Tawang.
Inner page 39.
Is a fam.
It is Lordship page 222.
222.
Lordship.
Assam, Dhubri.
Dhubri, South Salmara, Karimganj, Chirang, Baksa, Dorong, and Rangia. So
Okay.
since Cambrai Anglong was not included, Lordship, when it is given, it was came to our notice, we withdraw that. In any case, Lordship, they will be getting special duty allowance and others detachment allowance, which will be the 10% of their basic pay. So they have to give an option. They have not given option. They'll be receiving the special duty allowance as well as the detachment allowance, which will be 10% of their basic pay. That they will be getting. It will be minor difference, Lordship. In any case, Lordship, the Lordship may direct, because the matter is under active consideration, whether that will be continued or not before the authority. So let the authority take a
No,
call.
are you saying that if they opt for that special duty,
There will be minor difference between.
then the difference between hardship allowance and this special duty would be very minor,
Very minor.
which you are not going to recover.
Recovery part, that's leave it to Lordship.
No, are you going to recover or not?
There is a stay order. Then we can adjust, Lordship.
But they are still in service. You
They
can
are in
recover.
service. They are in service. They are very much.
If there is a mistake being committed in granting that, the recovery will be there, but the recovery will be very minor. Have you stated the same in your affidavit that they will be entitled to special duty and allowances, which will be 10% instead of hardship allowance?
Lordship. Paragraph 9, Lordship.
Okay, stipulate the following option to choose one of % of allowance, risk and hardship allowance as were applicable plus ration money, or detachment allowance plus ration or top location allowance. According in the event of the risk of being in an all officers commanding the also directly to apply the personal option of Yes.
Yes, my lord. In my petition, my lord, page
No,
128.
tell me, are you entitled to both?
No, my lord, one, my lord.
You're entitled to one, either hardship or detachment.
Yes.
Now, if you are not entitled to hardship, you are entitled to detachment.
Yes.
Why haven't you not exercised the option?
My lord, that is my lord, less amount, my lord. Detachment allowance, my lord, if my lord, that was 9,700. Detachment allowance, my lord, per day, my lord, 30 rupees, something, my lord.
Is it so? Are you saying that?
30,
No,
100,
they
100
said
rupees, my lord.
10% of the basic pay.
They say 10%, special duty allowance at 10% of the basic pay. Is your basic pay 300 rupees? Or 3,000 rupees?
As per my instruction,
No, 300.
sorry, my lord, not 30. About
No,
my
they have put it on affidavit.
100 rupees.
Is your basic pay 1,000 rupees? They are saying 10% of the basic pay.
Yes, basic pay, my lord.
So if it is 10,000 is the basic pay,
1.
10%. Obviously, if it is 100, it is 10, 100. Is your salary 1,000 rupees? So it will be more than that.
Yes.
Then why you are saying that it will be low?
Something like a less.
Huh?
Something low. Yes, something less.
But something less. You have to come up.
Lordship, we have stated in Annexure G that we will adjust this lump sum, Lordship, without so that no hardship is caused to them. Annexure G, Lordship.
Page?
Page 238.
238.
It's a WT message, Lordship.
First of all, you don't come within the ambit of high altitude because it is not there in the notification. Yes, admissibility of risk and allowance to spend. This one.
Lordship. In the event of non-admissible risk allowance, the personnel posted in this battalion are entitled to draw TADA with SDA at the rate of 10% of basic pay. Hence, if
Where you are reading? Page?
1, 2, 3, 4, 5, 6, 7, 8 line from bottom, Lordship.
Where? Page 239.
Page 238, Annexure G, Lordship.
Okay. In connection, it is submitted that 20 battalion. That one? 20 battalion CRPF is deployed at District Karbi Anglong since April 2008 with they mention here that the Karbi Anglong is one of the remotest areas of Assam, Northeast, which is heavily infested with a number of hill-based regular threats to the local malaria areas. Based on the 6 pay recommendations so that NC and unified field area of royal risk and unified association. Accordingly, the unit has been defined risk modified. So this is only for review. This doesn't say anything about
Like it's a proposal given to so that can be adjusted without that.
where which line you refer?
Hence, 1, 2, 3,
Page
4, 5, 6,
239.
7, 8. 39 is Hindi portion, Hindi version, Lordship. And
No, you are referring to some other page. Page 53.
238, page 55, Lordship.
Okay.
Page 55.
Page 55.
Signal, Lordship.
This is a signal.
Signal, Lordship.
In addition, it is
8th line from bottom, Lordship. Hence, if feasible on receipt of sanctioned order of SDA, the amount of RH in respect of all persons may be adjusted in lump sum so that the personnel do not face extra burden altogether.
No. These persons are entitled to TA/DA with SDA.
SDA.
Total of which is 10%.
Lordship.
SDA is not 10%.
Lordship.
This is wrong from your affidavit.
Lordship. TA/DA with SDA, maybe, Lordship.
No, what maybe? You are the person who is
Now,
filing.
I have stated it.
You see, in your affidavit, you say the special duty allowance at the rate of 10% at page 190.
Lordship.
Isn't this contrary?
Now it says detachment allowance, the special duty allowance at the rate of 10% of their basic pay.
Yes.
Could be sanctioned to them.
Then it is different. Hence, if feasible on receipt of sanction order of SDA, the amount of RHA is required to have to lump sum so that the personnel do not extra burden altogether. So then, that is why he is saying he's strongly
Lordship,
opposing you.
If I understand correctly, Lordship, entitled to draw TA/DA with SDA at the rate of 10%. So TA/DA plus SDA at the rate of 10%, Lordship. That is what they meant to say.
And Mr. Counsel, you have not replied to the paragraph number 9 of your affidavit. Affidavit 5 to 13, you are saying no comments.
Yes,
That means, is it the same? Are you not admitting what they are saying?
They are saying SDA and equal lordship in my petition, page 128, my lord. There is my lord Karbi Anglong was included. 128, my lord.
Page?
Page 128, my lord, in my receipt. Annexure 5, my lord.
120. This is a part of which document?
Yes, my
2019.
Yes, my 25th July 2019.
Page 128.
Yes, my lord.
Where is it mentioned?
Yes. 135, my yes. Assam, my lord. Long Depot, my lord.
What is this document then?
This, my lord, proposal, my lord, to the understanding is directed to say that after containing the order of enhanced risk and hardship, enhanced, my lord.
No, this is only for recommendation
Yes,
for upgrade.
recommendation.
Yes, Lordship.
They
this
have
is
not
only
upgraded.
Yes, my lord, what happened, my lord? In 2019, they have enhanced, my lord. But my lord, 7,649 was, my lord, in our company, my lord, then before, my lord, before also 7,649. If your lordship kindly see approval order, my lord, annexure 6, my lord. Here, my lord, in place of 7,469, 9,700 was, my lord,
Given to you.
Yes, given. But my lord, 7,469 was also stopped, my lord. That is, my lord, enhanced.
Now what do you want? 7,469.
Yes, my lord, if my lord lordship 7,469.
It's okay. No, Mr. Chakraborty, I don't think this matter can be disposed of in this manner. Because I give it, then again they have to come. Makes no sense. So you do one thing, you get your instructions. Why this upgradation has not happened? And also as to whether it is 10%. What is the difference?
What will be the difference between
Let us
what
know
they are
what is
getting
the
and
difference. You have stated in your paragraph that either they are entitled to hardship or the detachment. If they are entitled to the detachment, what is the difference? And what is the stage of the recommendation being made for upgradation and inserting curbing? I think that is the thing.
they were given in anticipating that this recommendation will get the approval. Later on, it did not get the approval, so we
Now,
withdraw.
is it the case that it has not got approval or it is under consideration?
Now the
Now
matter is under
In my
consideration.
affidavit, my lord, there is a letter on 20.
Okay, heard, Mr.
Empoli.
The learned counsel appearing on behalf of the petitioner, Mr. P. Chakraborty appears on behalf of the respondent. The petitioners herein who belong to the Central Reserve, Central
CRPF.
Reserve Police Force have been rendering service in the Karbi Anglong district of Assam. The petitioners initially were paid a hardship, the risk and hardship allowances of an amount of rupees
469.
7,460.
69.
Thereupon, the said amount was increased to rupees 9,700. Subsequent thereto, the authorities concerned completely stopped payment of the said risk and hardship allowances. Being aggrieved, the instant petition has been filed. The claim of the petitioner is based upon the office memorandum dated 31/7/2017. On the other hand, the learned counsel appearing on behalf of the respondents have submitted that there is a schedule to the office memorandum dated 22/2/2019, wherein in respect to Assam, various districts have been mentioned. However, the district of Karbi Anglong is not there. And as such, the entitlement of the petitioner on the ground of risk and hardship allowances cannot be there till the office memorandum dated 22/2/2019 is modified. It has also been submitted that the petitioners herein, in terms with the office memorandum dated 31/7/2017, had the option of choosing number A, risk and hardship allowances, bracket, as and where applicable, bracket close, plus ration money allowance, or B, detachment allowance plus, inverted bracket open, special duty allowance, bracket, small bracket, as and where applicable, bracket close, or who are capital, sub location allowance, bracket close, open, as and where applicable, bracket close. It has been mentioned that the petitioners are not entitled in view of the office memorandum dated 22/2/2019 to the risk and hardship allowance. However, the petitioners are entitled to where is the page? That page we have said 10%.
Lordship, page 55.
Accordingly, are not entitled in view of the office memorandum date, the notification dated 22/2/2019. However, the petitioners are entitled to the detachment allowance, the special duty allowance at the rate of 10% of their basic pay. With effect from 22/2/2019. It is also the categorical case of the respondent that the petitioners here have not exercised their option for which the petitioners could not be paid the detachment allowance, the special duty allowance at the rate of 10% of their basic pay. A reference was also made, and this court, upon hearing the matter, have also perused a document issued by the Commandant 2nd 28th Battalion, issued of the dated 30/7/2020, wherein the Deputy Inspector General of Police CRPF was requested to review the notification dated 22/2/2019 by including the District of Karbi Anglong within the ambit of risk public hardship, within the ambit of the entitlement of the risk and hardship allowances. It is also relevant to mention that the Commandant of the 28th Battalion have also issued a signal dated 30/9/2020, wherein it is mentioned that in order to not put the petitioners in hardship, the recovery shall be made by adjusting in lump sum so that the personnel do not face extra burden altogether. This court, further hearing the matter, also made a query upon the learned counsel appearing on behalf of the respondents as to what is the present status of the recommendations so made for including the district of Karbi Anglong for the entitlement of the hardship and risk and hardship allowances. The learned counsel appearing on behalf of the respondent submitted the same is presently under consideration. This court further inquired with the learned counsel for the respondent as to what would be the difference between the allowance given on the ground of risk and hardship and the special detachment
allowance plus SDA.
Plus
SDA.
LCA.
Special duty allowance.
LCA. The learned counsel appearing on behalf of the respondent submitted that he would require some time to apprise this court as regards the development insofar as the consideration of the respondent authorities in respect to consideration which is pending before the respondent authorities for including as to whether the district of Karbi Anglong is required to be brought within the ambit of the notification dated 22/2/2019 and also as to what would be the difference between the two allowances as have been mentioned in the affidavit. List the matter again on 29th of May, on which date the learned counsel for the respondents shall apprise this court as regards the queries so made.
Both order, same order in both the cases.
I think then it is serve you more. If I send it out there, you know, at the mercy of them.
Yes, right.
Item number 67.
This matter yesterday a lot them whether the departmental inquiry has been initiated or not.
Yes.
Lordship, page 75, Lordship. He was appointed as the inquiry officer, Lordship, on 7/6/2022, Lordship. Lordship, by the end of December, this person got transferred, Lordship. And no new person has been appointed as inquiry officer, Lordship.
Why?
It is pending like that.
No, but he has not got his pension and all these things.
Lordship, may I submit, Lordship?
Yes.
Lordship may pass a direction, Lordship, asking directing the authority to complete the inquiry within a limited period of time, Lordship. Lordship may dispose of this matter in that
We in fact, I would like to submit on that. My case is basically based on the fact that inquiry was not done for the last 7 years. And secondly, because of this, all my pensionary benefits and other service benefits have been held up. Now, if they are not interested in completing the inquiry or whatever may be the reasons, then either they are appointing on after 7 years they have appointed an inquiry officer. There is a maximum delay. Now that a person goes, whether they were inclined to have any other person or not for the last 4 months, that is also not. In that case, why your lordship will direct them to complete the inquiry?
No, I will direct them to complete it within 1 month, else the entire proceedings will be honest, and then you will be entitled to.
And my amount will be held up to you.
No, then you will be entitled to all your benefits. If they do it within 1 month, well and good.
But then
that is the only thing. Let them do it within 1 month.
And lordship will specifically state that since I have retired already 2 years back. So I have retired 2 years back. So without money, it is very difficult. That is one issue. That is what
No, that time obviously. I'm passing the order in your presence.
Yes.
If anything is there, you let me know.
Sure.
Heard Mr. Y.S. Manan, the learned counsel, appearing on behalf of the petitioner. Mr. Yes. P. Naik appears on behalf of the respondent numbers 1 to 4.
1, 2, 3, and 4, all lot.
1 to 4. The case of the petitioner herein is that the petitioner was initially appointed as a Mazdoor in the assessment branch, Jurod, of the respondent number 1. Thereupon, the petitioner was appointed as the LD assistant, assessment branch, by an order dated 26/12/1987, issued by the Commissioner GMC. Subsequent thereto, by an order dated 26/2013, the petitioner was promoted as the Deputy License Officer at Dispute Zone of the GMC, issued by the Commissioner GMC. Thereupon, on 19/1/2015, the Commissioner GMC had put the petitioner under had placed the petitioner under suspension pending broil of departmental proceeding with immediate effect. At this stage, it is relevant to take note of that that an FI was filed against the petitioner before the dispute police station, and on the basis thereof, a dispute PS case number 112/2015 was registered under section 409 of the Indian Penal Code. Subsequent to the petitioner's suspension, on 19/3/2015, a show cause notice was issued to the petitioner under Rule 9 of the Assam Services (Discipline and Appeal Rules) rules 1964, hereinafter for short referred to as the Rules of 1964, read with Article 311 of the Constitution, as to why the penalties prescribed under Rule 7 of the Rules of 1964 should not be inflicted on the charge of gross negligence of duty and misappropriation of money. Petitioner, subsequent thereto, submitted a representation on 8/4/2015, stating inter alia that due to some inadvertent mistake, an amount of rupees 24,000 was misplaced, which the petitioner was ready to refund along with interest, and also requested the respondent authorities to revoke the suspension order and allow him to join his duties. A month thereafter, the petitioner had also submitted another application, another representation dated 8/5/2015, praying for release of subsistence allowance, and also that the petitioner was not allowed to inspect the documents which the petitioner had a right to do in terms with Rule 9 of the Rules of 1964. After 3 months thereafter, the Commissioner GMC accorded sanction for payment of subsistence allowance at the rate of 50% as per FR 53 for a period of 3 months with effect from 19/1/2015 to 18/4/2015. Did you get the 75%?
No, that was not.
Subsequent thereto, it is the case of the petitioner that the petitioner was not paid the subsistence allowance.
Though they have accorded approval, it was not. Approval was accorded, but it was not.
The petitioner, being aggrieved by the continuation of the suspension order, filed a writ petition being WPC number 7632/2015, challenging the order of suspension. This court, by an order dated 3/3/2016, disposed of the writ petition with a direction to the Commissioner GMC to revoke the suspension order dated 19/1/2015 within a period of 30 days from the date of receipt of the certified copy of the order. Thereupon, in compliance to the order dated 3/3/2016, on 28/4/2016, the petitioner was reinstated to his service. And upon his reinstatement, the petitioner was transferred and posted as Deputy Rank Officer, Central Registry Branch, GMC. And the petitioner joined upon reinstatement on 28/4/2016 itself. Thereafter, did you get your salary, Mr. Manan?
No, that was not.
You didn't get your salary
No, salary I got, but
after reinstatement?
after reinstate I got the salary, but pensionary benefit.
No, you have got the salary till your retirement.
And but the amount of
Subsistence allowance you have not. The petitioner thereupon continued to render his service and retired on 31/3/2020. It is the further case of the petitioner that although the respondent authorities have sanctioned the subsistence allowance at the rate of 75% by an order dated 3/6/2016, but the said subsistence allowance was not paid. That is for the period from 19/4/2015 to 27/4/2016. In the meantime, the dispute PS case number PS case number
112 of 2015.
112/2015. 2015
Judgment is page
was charge sheeted. And thereupon it be a case being GR case number 614/2015 was registered. By the judgment and order dated 11/2/2022, the Court of the Additional Chief Judicial Magistrate, Kamrup Metro at Guwahati, held that the prosecution could not prove the case against the accused person beyond the reasonable doubt. And accordingly, the petitioner was acquitted of all charges and set at liberty forthwith. It is relevant at this stage to take note of. Where is the document where it says that pending pursuant to the criminal? Yes, yes. But it is relevant to take note of that the petitioner in the meantime was continuously pursuing his claim as regards the subsistence allowance at the rate of 75% for the period above mentioned. And the Commissioner of Guwahati Municipal Corporation by the communication dated 27/3/2019 had observed that as the criminal proceedings is going against the petitioner in the court of law, the applications of the petitioner for his outstanding dues cannot be considered till the disposal of the state court case. It further appears from the records that pursuant to the judgment and order dated 11/2/2022 passed by the additional chief judicial magistrate, the petitioner submitted again another representation on 23/2/2022, drawing to the attention of the commissioner of the GMC that the petitioner have been acquitted by the court and as such to release his legitimate dues at the earliest. It is also relevant to take note of that petitioner retired as on 31/3/2020, and the petitioner thereupon have not received any pension or his pensionary benefits till date. Pursuant to this representation submitted on 23/2/2022, the Commissioner of Guwahati Municipal Corporation, on the basis of the show cause notice issued on 19/3/2015, passed an order for proceeding with the inquiry in terms with Rule 9 of the Rules of 1964, and accordingly appointed one Sri Pankaj Chakraborty, AC as Joint Commissioner -2 GMC as the inquiring officer. The petitioner being aggrieved by the reinitiation of the inquiry proceedings after a lapse of 7 years, as well as for the non-payment of his outstanding dues, as well as of his pension and other pensionary benefits, have approached this court by filing the instant writ petition. This court, by an order dated 12/8/2022, issued notice making it returnable by 4 weeks. Thereupon, it appears that the respondent, GMC, have been granted time to file the affidavit on 2/11/2022, 5/12/2022, and till date, no affidavit have been filed. When a matter was listed yesterday, that is on 25/4/2023, this court put a specific query upon the learned counsel appearing on behalf of the GMC as regards the status of the inquiry proceedings, so initiated against the petitioner. Today, when the matter is taken up, the learned counsel appearing on behalf of the respondent number 1 to 4 submitted that the inquiry officer who was appointed by the order dated 7/6/2022 had been transferred out of the GMC, and as such, transferred out of the respondent corporation in the month of December 2022 itself. And thereupon, there has been no appointment of an inquiry officer till date. He, however, submits that steps are being initiated for appointment of an inquiry officer. Be that as it may, from the perusal of the materials on record, it is apparent that the petitioner, in terms with FR 53, was entitled to the subsistence allowance at the rate of 75% after the initial period of 3 months. From 19/4/2015 to 27/4/2016. 27/4/2016. 28 you joined.
It was revoked and I joined.
28 you joined. So from that day you have got the salary. So you are entitled for the subsistence allowance. 27/4/2016. This right to get the subsistence allowance could not have been curtailed or deprived by the respondent authorities, more so when there has been already a sanction granted. Sanction already, the said amount had been sanctioned by an order dated 3/6/2016.
That is after the period of it.
Taking into account the same, this court therefore directs the respondents, more particularly the respondent number 2, to forthwith release the outstanding amount on account of subsistence allowance at the rate of 75% for the period from 19/4/2015 to 27/4/2016. Within a period of how much, Mr. 1 month?
3 months, Lordship. Otherwise,
No,
that
this
is
is 1
not
month.
clear,
This is 1 month. Subsistence allowance is sanctioned. Why haven't you paid that?
No, it was sanctioned in the year 2016.
That is your lookout. You shouldn't have done it.
Lordship. Otherwise, also that is not a prayer, I think. Lordship.
No, that is a prayer. His outstanding is a prayer, isn't it?
Subsistence allowance, Lordship.
Yes, it is his prayer, as well as the subsistence allowance from 19/1 AR till
Yes,
month.
Lord.
It is his prayer. Within a period of 1 month from the date, a certified copy of this order is served upon the respondent number 2. Now, coming into the question of the inquiry, it is the case of the petitioner herein that The inquiry was initiated on the basis of a criminal proceedings being initiated, a FIR being filed against the petitioner. The said FIR which was charge sheeted, upon being charge sheeted, and the petitioner being acquitted by the order dated 11/2/2022. The question of reinitiation of the departmental proceedings against the petitioner, that too after the retirement of the petitioner, is nothing but an abuse of the process of the court, abuse of the powers by the respondent authorities. On the other hand, Mr. P. Nayak, the learned counsel appearing on behalf of the GMC, submitted that an acquittal under the criminal proceedings cannot be taken as a cannot be taken that the petitioner have been exonerated in a departmental proceedings. And this aspect of the matter is no longer res intriga. He further submitted that pursuant to the inquiry, pursuant to the criminal proceedings, the departmental proceedings was initiated, and it was on account of the transfer of the earlier inquiry officer, for which the inquiry proceedings could not be completed.
Just one more thing, Lordship. So-cause notice was issued in the year 2015.
Understood. That is why I'm saying reinitiation.
Yes, Lordship.
I've never said that you have initiated now.
Lordship. One more thing is there, one representation is there, Lordship. There he admitted this guilt, Lordship.
I've seen it. I've recorded that also, that he said that he is going to pay the 24,000. I've recorded that aspect. No, he said that there was a mistake. He's going to ready to pay the 24,000 along with interest. He said it. I've recorded that.
Document is already recorded. I have
Okay. Yes, last line to Coxon power.
Sorry. I'm sorry. Sorry, Lord.
Inquiry officer, for which the inquiry proceedings could not be brought to a logical conclusion. The learned counsel further submitted that steps are being taken for appointment of an inquiry officer so that the inquiry could be completed within a stipulated period of time. He further submitted that the right of pension as well as the other pensionary benefits would depend upon the outcome in the inquiry proceedings. And as such, the question of issuing any direction at this stage does not arise, pending disposal of the said departmental proceedings. I've given my anxious consideration to the matter. This court.
Lordship, can I make one submission which I made yesterday, that they could not keep a departmental inquiry pending for a period of 7 years. Now they are initiating it after my retirement.
They are not initiating it.
Reinitiate.
The thing which was there.
7 years. So yesterday I pointed out that part will not work.
No, I've already mentioned, no?
7 years.
You want the 7 years, we'll put it, but 7 years or otherwise, you have already done on pay. I've already mentioned
Yes,
that.
that is there.
No.
So there is a delay, that delay part you lost back.
I've given my anxious consideration to the matter. Though it is the submission of the learned counsel appearing on behalf of the petitioner that the departmental proceedings was initiated on 19/1/2015. And thereupon, after the petitioner have filed their show cause notice, the respondent authorities was completely silent in respect to the departmental proceedings. And it is only after a period of 7 years the said departmental proceedings was re-initiated by appointment of an inquiry officer on 7/6/2022. However, one aspect of the matter cannot be lost sight of. That an acquittal in a criminal proceedings and an exoneration in a departmental proceedings are completely two different aspects of the matter. In as much as in an acquittal, in a criminal proceeding, in as much as in a criminal proceeding, the yardstick applied for evidence is beyond reasonable doubt, which, however, is different in the case of a departmental proceedings. The departmental proceedings, though initially initiated on 19/1/2015, but no action was taken in view of the pendency of the criminal proceedings. Thereupon, when the respondent authorities were informed about the order passed in the criminal proceedings, the respondents took steps by the order dated 7/6/2022 to appoint the inquiry officer. It is the opinion of this court that the responding authorities have a right to continue with the said departmental proceedings after the criminal proceedings was over. It is also relevant to take note of that the petitioner, as of now, the petitioner had retired as on 30/3/2022. 20. And for the last more than 3 years, the petitioner has been without any pension or any other pensionary benefits. A further delay much delay in bringing the departmental proceedings to a logical conclusion would affect the right of the petitioner to continue a life, continue a retired life with dignity. Which is a facet of Article 21 of the Constitution. Consequently, this court, therefore, while permitting the respondent authorities to continue with the departmental proceedings, is of the opinion that the said departmental proceedings has to be brought to a logical conclusion within a period of 2 months. 1 month is too short. Don't ask for 3 months.
Okay.
Within a period of 2 months. From today?
Data certificate.
You know it now. That's who you know. Within 2 months. From the date a certified copy of this order is served upon the respondent number 2. It is made clear that if the departmental proceedings cannot be brought to a logical conclusion within the period of 2 months, as stipulated herein, the said departmental proceedings has to be treated as
Should be closed. Because there is nothing what to say.
and there is a term used. No? I thought Mr. Manan will come up with such term.
No, I am not prepared
Eh?
with that term. I did not
Think we have
think
to
about that.
close.
What was what exactly your lordship is thinking? I did not think. Anyway, it was whatever your lordship thinks. I think,
I'll put that word. Will be
Yeah.
deemed to closed. And the petitioner thereupon shall be entitled to all the pension and other benefits to which the petitioner would be otherwise entitled to in accordance with law. It is further mentioned that in the eventuality the departmental proceedings are brought to a logical conclusion, where is that particular so-called?
Focus is that case 29. Oh,
Huh?
sorry, 30.
Brought to a logical conclusion. And the penalty imposed is not a penalty within the ambit of Rule 7, Roman 8. it is further observed that if in the eventuality the departmental proceedings are brought to a logical conclusion, you come under the rules of 69.
Yes.
Then the governor has to exercise the power under 21.
If it is initiated after retirement.
No. For depriving a person from pension, the governor has to exercise the power under 21,
Not
isn't it?
in the name of the governor.
Even it is the governor who has to do it, but it is in the name of the governor. Brought to a logical conclusion, then only. And in the penalties so awarded, now to all these dismissal, suspension service doesn't arise, he has retired.
Yes.
So it has to be an action under 21. Otherwise, you can't restore it.
Only withholding, but Lordship may not like to go to that extent, Lordship. So far as my instruction is concerned, probably it will be limited to the 24,000 only of the record, Lord. So Lordship may not.
In that case, your Lordship, since he is dead, then your Lordship may not go into that.
Yes, Lordship. We will
Hello.
complete within a
Then
year.
yeah, it will be there. আগৰ এইটোত কিমান দিলো, it shall be delayed as is closed, and accordingly the petitioner would be entitled to all his pensionary year, which shall be processed within a period of 3 months therefrom. That pension and pensionary benefits within 3 months from the date of these 2 months.
It will be completed, my Lord.
No, these 2 months I have given you
Lordship.
for completion of the departmental proceedings, and thereafter I'm giving you 3 months. If I'm closing it, 3 months thereafter, he will be you have to clear
If
his.
he is otherwise entitled. Yes.
Then I won't go into the other
That
aspect.
part is better. Otherwise, since they are not inclined to give a punishment.
Huh?
Since they are not inclined to give a punishment, it's better to end it there.
No, I'm worried that if they do want to do so, because otherwise the thing is, normally it is they would not have taken that step of initiating the departmental thing.
No, in fact, because of the fact that I claim my dues and everything, then they issued that order. And thereafter, all the officers went inside for a long period of time. So they know themselves.
So I have kept it 2 months and 3 months. And this within 1 month.
The subsistence. Much.
Item number 11.
Lordship, I have instruction.
Oh yes, tell me.
A certified copy was, my lord, The petitioner went
The
to
price
the
is
office
put
of
on the
the
next date from
Treasury officer
when
Ramkrishna
the
Ramal.
petitioner would be entitled to family pension. In the meantime, pay is directed to disburse the family pension to the petitioner number 1 on the basis of the complicated 17.2. Yes.
My lord, went to office of my lord Treasury officer Ramkrishna to furnish the certified copy. My lord.
Huh?
Petitioner went to furnish the certified copy of this order, my lord, 11.4. But the concerned court refused to acknowledge. So, my lord, certified copy was sent by the star post with that, my lord.
Who?
Well, petitioner, my lord. As per order 11/4/2023, my lord. This order, certified copy of this order, my lord. Petitioner is directed to serve the copy of the instant order, my lord, to the Treasury officer Ramkrishna Rao.
Why did you send it by registered post?
He went to the my lord, serve the copy, my lord, but he, they refused to, my lord, acknowledge the receipt, my lord. So, my lord, sent by registered post, my lord.
Now, what is the status?
No, even my lord, I had a telephonic communication with the treasury officer. He said, my lord, that once that mandate is received, my lord, he will do the needful.
Which mandate?
My
From
lord, that, yes, from the
you have
office of
given?
the account. It will be done. It's the
Status
regular official
I
process.
am to inform you the date of commencement of the unmarried daughter's pension with effect from 9/9. That is that from the date of forwarding the application by the that the note fee of the notification the family member shall be paid from the date of filing by the claimant. Now, have you given the mandate? Pension payment order done. What is your name? An expiration of every month to please pay an amount of rupees pay Manjuri Sinha, unmarried dependent daughter, the pension. Yes. Oh, it has been given. So pension payment order has been given to the treasury officer.
And my lord, the period from which my lord she is entitled.
It is given from 9/9/2019.
And this as per my lord, petitioner will have to, my lord, give the details of the bank account because treasury officer nowadays, my lord, cash transactions are not taking place. He is also, my lord, duty bound to.
That is why I asked you to go there.
She went there 2 times, my lord. And the account number was furnished along with the application, my lord, format application, which was annexed, my lord. Page 40, my lord. Format application was furnished, my lord.
40.
Page 40, 42, my type copy is 40, my lord.
Now, where is your bank account? Huh? Where is your bank account?
Copy of passbook, my lord, 46, my lord. Page
Mr.
40.
Counsel,
Yes, ma'am.
I hope you want everything in the platter that this court is going to do all these things. Huh? They have done the PPO. Now it is yours. After you don't get the PPO has been issued when? What is the date of the PPO, Mr. Ahmed?
My lord, it is and it is on written, my lord, 13/2/2023, my lord. This order, which was communicated on being received, this order petitioner went to the treasury officer, my lord. If informed that he has not received PPO, so cannot do. Then, my lord, order was passed to furnish the certified copy. Petitioner went there and they refused to acknowledge, so petitioner sent it by registered post. That is the thing, my lord. And regarding, my lord, passbook, page 44, my lord, it was the copy which was written, my lord, serial number 10, copy of passbooks, my lord. Page 40, that was provided. Page 46, my lord.
Page
46.
Yes.
Serial number 10, my lord.
Format.
Page 46, my lord, is an inter-office communication. This is no way related to the treasury officer. The inter-office communication. Lordship may kindly come to page 42.
No, I do. You mean to say that the petitioner, after giving all these details to the line department, thereafter have to go again to the treasury officer?
No.
Then this has already been done. He is already given the passbook.
Only requirement. Therefore, my lord, I am drawing
PAN
my
card
lord.
he has given.
No, bank account. Lordship will kindly see page 42 of the writ petition. Page 42. It is her application, petitioner's application.
Yes.
Page 42.
Hmm.
Then page 42 nowhere mentions the bank account. Page 42 nowhere mentions the bank account. Then my lord will kindly see.
You have the bank account number?
No, at present I don't have.
Then, my lord, how can it be done?
It was already, my lord, provided copy was, my lord, as per the.
Understood. Then I will close it. You go and go to the treasury
Making
officer.
accusations, my lord.
You go to the treasury officer. This coach, if you don't have the bank account, I can't help it.
No, my lord. that
Heard
was-
Mr. S.K. Sinha, the learned counsel,
present, my
appearing
lord.
on behalf
Sorry,
of the
my lord.
petitioner.
At present, I don't have the bank account, my lord, at present.
Mr. R. Ahmed appears on behalf of the Principal Accountant General AE. Ms. M. D. Bora appears on behalf of the Director of Pension. Director of Pension. Okay. And Mr. R. Borpujari appears on behalf of the Treasury Officer.
My lord, 2 and 7. Financial
2 and
officer.
7.
My lord.
I have the copy, my lord, Xerox copy in my file, my lord, bank account.
Mr. Counsel, take that order, do whatever you want. You go to the Supreme Court, go to the division bench, wherever you know. The petitioner herein has approached this court, being aggrieved by not granting of the family pension to the petitioner. To the petitioners. It has been brought to the attention of this court as recorded in the order dated 11/4/2023 that the petitioner number 2 had already expired. And as such, the entitlement of the petitioner herein would be limited to the petitioner number 1 for family pension. On 11/4/2023, when the matter came up, the counsel appearing on behalf of the Principal Accountant General AE had submitted that the family pension payment order number 932-422-2 97823 932-422-97823 has already been issued in favor of the petitioner, thereby entitling the petitioner to an amount of rupees 8760 per month with effect from 8760 per month. However, as per the instructions which was produced on 11/4/2023, it was not clear as to from what date the petitioner would be entitled to. This court directed the counsel appearing on behalf of the Principal Accountant General AE Assam to apprise as to when the petitioner number 1 would be entitled to family pension. This court further directed the Treasury Officer Ram Krishnanagar to disburse the family pension to the petitioner number 1 on the basis of the order dated 17/2/2023. And the petitioner was directed to serve a copy of the instant order to the Treasury Officer Ramakrishna Nagar for due compliance. Today, when the matter has been listed, the learned counsel, Mr. R. Ahmed, appearing on behalf of the Office of the Principal Accountant General AE, have produced the pension payment order bearing number, hey, number 2 932-422-97823, wherein it has been mentioned that the payment of the family pension would commence from 9/9/2019. This pension payment order have also been produced before this court, which is kept on record. The instructions were produced by Mr. R. Ahmed is also kept on record and marked with the letter Y. Taking into account the same, this court therefore disposes of this requisition with a direction to the Treasury Officer Ramakrishna Nagar for to comply. No, sorry. This court further would like to take note of the submission made by the learned counsel appearing on behalf of the petitioner who submitted that in pursuance to the order dated 11/4/2022, 23, the petitioner had approached the Treasury Officer Ramakrishna Nagar, who informed the petitioner that upon receipt of the PPO,
Not yesterday, my lord, earlier, my lord. On being received the my lord, PPO order, petitioner went there, and yesterday, my lord, she went to furnish the certified copy of this order. Then that was not acknowledged. So
submitted that the petitioner, pursuant to the order dated 11/4/2023, approached the Treasury Officer Ramakrishna Nagar on 20. Today is what? 23. On 25/4/2023, when the Treasury Officer Ramakrishna Nagar had directed the petitioner to send it by registered post.
no, my lord. Treasury officer was not available at the office, my lord. Concerned clerk refused to acknowledge, so the certified copy was sent by registered post, my lord. Yesterday, my lord.
Okay, David, you have directed to give on 11/4.
Yes, that was, my lord. It was sent by
11/4. Why did it take 16 days?
that certified copy was obtained by lord 12, my lord. Then-
It is also relevant to take note of. Itu line to Agor to follow and also directed to pay the, on the basis of the order dated 72/2023. I said it. Accordingly, this court therefore disposes of this petition with a direction upon the Treasury Officer Ramakrishna Nagar to pass appropriate orders as deemed necessary so that the petitioner receives her family pension in terms with the pension payment order. A copy of the instant order be given to the registry is directed to serve a copy of the instant order to Mr. R. Bupajari, the learned counsel appearing on behalf of the Treasury Officer, so that the instant order can be duly communicated to the state authority. Respond number 4. What about 5?
5, I think he did not enter the appearance. Sir, 5 has left this institution and joined in some other stage.
Subsequently, he joined in Borpeta, my lord.
Taking into account the dispute involved herein and the order which this court proposes to pass, this court does not feel the presence of the respondent number 5 is not essential. The case of the petitioner herein is that the petitioner is the headmistress.
Yes, madam.
Was or is?
Was, madam.
Was the headmistress of a school in the name of
Bowalguri Pre-Senior Madrasa.
Bowalguri Senior Madrasa. On the basis of an inquiry report dated 2/5/2015, the respondent number 5 was put under suspension and the block elementary education officer was directed to file an FIR against the respondent number 5. It further reveals from the contents of the petition that a disciplinary action proceedings was initiated against the respondent number 5 and in pursuance thereto, the punishment in terms with Rule 7 Roman 2 of the Assam Service Bracket Discipline and Appeal Rules 1964 was imposed by withholding 2 increment with cumulative effect. It was further mentioned that at the time, further mentioned no, further to that, the respondent number 5 was reinstated and posted as the head Mudaris to Sangmaji Pre-Senior Madrasa against the vacant post of head Mudaris, and it was clarified that the suspension period of the said incumbent shall be treated as on duty for the purpose of counting the pensionary benefit. However, the respondent number 5, as alleged, did not join as the head Mudrasis of Sangmaji Pre-Senior Madrasa. And continuously pursued before the office of the respondent number 2 with a request for modification of the order dated 3/12/2018. Thereupon, the respondent number 2 passed an order dated 12/2/2019, whereby the said respondent number 5 or 6, 5, yeah, 5, was reposted at Bowalguri Pre-Senior Madrasa with immediate effect. One of a guardian of a student who was studying in Bowalguri Pre-Senior Madrasa, being aggrieved by the order dated 12/2/2019, approached this court by challenging the same on the ground that the aforesaid order dated 12/2/2019 was violating the settled position of law as well as in violation to the Assam Service Bracket Discipline and Appeal Rules 1964, the Right to Free and Compulsory Education Act 2009, as well as the other relevant provisions of law. This court, by an order dated 25, the said petition was registered and numbered as, where is that?
My lord, at page 30, WP2 118, page 30.
Was registered and numbered as WPC number 1186/2019. This court, by an order dated 25/2/2019, state the order dated 12/2/2019 whereby the respondent number 5 herein was posted as head mudari of Bawalguri Pre-Senior Madrasa until further orders. Under such circumstances, the respondent number 5 could not join the post of head mudaris in the school where the petitioner was the headmistress.
Insert.
Thereupon, an order was issued by the inspector of schools on 8/7/2019 whereby it was mentioned that the respondent number 5 was entitled to subsistence allowance at the rate of 75% as per government rules and procedure. The petitioner thereupon, the issue, therefore, which arose with the petitioner is to how the petitioner could release the subsistence allowance of 75% to the respondent number 5, in as much as his posting by order dated 12/2/2019 was stayed by this court. By the order dated 25/2/2019 in WPC number 1186/2019. Subsequent thereto, to the utter surprise of the petitioner, a show cause notice was issued by the inspector of schools on the ground that the petitioner failed to carry out the order of the higher authority of directing the payment of 75% of the subsistence allowance to the respondent number 5. The petitioner herein challenged the order dated 8/7/2019 as well as the show cause notice dated 1/8/2019. It is the specific case of the petitioner that the said order dated 8/7/2019 could not have been issued in view of the order of stay dated 25/2/2019 passed in WPC number 1186/2019. It is further submitted by the learned counsel appearing on behalf of the petitioner that the issuance of the show cause notice was completely perverse in as much as it was based upon non-existent facts and also on the basis of an order of a higher authority which could not be complied with in view of the order passed by this court. It appears from the record that upon filing of the instant writ petition, this court, while the order dated 23/9/2019 issue notice making it returnable by 4 weeks, and in the meantime state the impugn order date, impugn notice dated 1/8/2019. Till date, as would appear from the records, the respondents have not filed their affidavits. The learned counsel for the petitioner submitted that in the meantime, you have retired?
No, no, my lord. This
You are working?
working.
Okay. On the other, this court made a specific query upon the learned counsel appearing on behalf of the secondary education department as to what is the status of the departmental proceedings so initiated against the petitioner. The learned counsel for the secondary education department submits that pursuant to the said Shoko's notice, nothing has been done in view of the stay order being passed by this court on 23/9/2019. He further submitted that in the meantime, the respondent number 5 have also been transferred to some other school in the Borpeta district. I've heard the learned counsels for the parties and have perused the materials on record. A perusal of the order dated 8/7/2019 in the opinion of this court is an order honest in as much as there was an order of stay passed by this court whereby the petitioner, respondent number 5, whereby the order of posting of the respondent number 5 dated 12/2/2019 was stayed. And as such, the question of payment of the subsistence allowances by the petitioner, being the drawing and disbursing officer, in respect to the school in question did not arise. As the order dated 8/7/2019 is honest, the Shoko's notice which has been issued on the basis thereof for non-compliance of the said order is also based upon non-existent facts. And as such, this court is of the opinion that the said Shoko's notice dated 1/8/2019 has to be nipped at the bud. Consequently, this court therefore sets aside the Shoko's notice dated 1/8/2019. Accordingly, the instant petition stands allowed in terms of the observations and directions made herein above. The unnecessarily filing
Item
affidavits.
28.
Yes, sir.
It matters no. Yes, Mr. Thor.
Yeah, Lordship, the
You
petitioner was-
wanted this matter to be upgraded. Why?
Lordship, here the petitioner was appointed as constable on 6/12/1992, and he served in the department for last 20 years. And in the year July 2021, he suffered with a serious ailment of backbone and spine problem. Thereafter, he consulted the medical and health officer in charge police hospital Silchar, and the senior medical officer referred the case of the petitioner for better treatment and surgery to CMCH Vellore, Lord. Lordship will find at page 13. 13 middle portion, Lordship, advice referred to CMC Vellore for surgery.
Yes, madam.
Yes, we have filed our affidavit. Lordship.
You are the pension?
Yes, I am for department also, home department, 1, 2, and 3.
Okay, what do they say?
Kindly come to our affidavit. Lordship.
Yes, what do they say? He was on automatic leave.
He was absent from the service, Lordship, without informing. He was not present. Come to our affidavit, page 2, paragraph 4, Lordship.
Then what have you done?
Therefore, no work and no payment for that absent period.
Okay, how have you done that? Tell me also. This court also wants to know how is it possible? No work, no pay. Is it possible? Means, isn't it a penalty?
No, so many judgments are there, Lordship. I have to produce the.
No, one judgment, not only judgment. Show me the law. No, I understand. If you don't work, you don't get the payment. Very well. But if you want, how is it possible? Is it a case of no, he did not ask for leave.
Yes,
that is your case. Without taking leave, he has been absent for this period of 1 month.
1 month.
Isn't
45
it?
days.
45 days. He was not there. He says that he was under treatment and he must have submitted a subsequent leave statement. What have you done on that?
He has not informed to the department. Lordship.
Understood. But subsequently he has submitted. What have you done on that?
On that part, we have to take instruction.
You have filed an affidavit.
Yes.
His prayer is so short that what will means it is simple. It's a prayer is simple that you see why this particular period needs to not be reviewed as on duty or as on leave.
Commutation.
That is his prayer.
Yes, Lord.
Why? He has submitted. Have you submitted a leave application?
Several representation, Lord.
No, leave application.
No leaflet
Because their medical officer has has advised me for 1 month rest, Lord.
No leave application has
If we come to
Where's your leave application?
He have not informed even.
No, that he has not informed. But after coming back, has he informed?
Yes.
Prayer for modification of the order that I am been performing my duties sincerely and so. I proceeded to Vellore, but due to non-availability of concern, I was bound to shift to Patna. That as per the advice of I had to take bed rest of 1.5 months with effect from before filing a petition for granting for community leave. But surprisingly, I came to know that you are not taking my leave without pay. So he wanted this. Where is the leave for community leave?
No, I have submitted representation.
You want to go for voluntary retirement?
Commuting that period.
You're going for voluntary retirement?
Yes, he has
because I'm not in a position to serve.
He go for voluntary retirement.
Then? No, have you taken into consideration his application for commuted leave? That is the only question.
Yes, that's it.
If you have, why you have rejected?
On particular point, I have to take instruction. Lordship.
So your affidavit is useless.
Yes, Lord. Here it is not.
This too, you could have said it without the affidavit also, no pay, no work. It is apparent from the order itself, which he had challenged. But his case is that he has submitted an application for putting you, for giving him the commuted leave or something. But why haven't you given? You have given him a leave without pay. Why? Is he not entitled to that? There has to be some reason.
Yes, that's it.
Then what do? You come up with an instruction. When?
1 week time. Lordship.
Heard Mr. Adhar, the learned counsel appearing on behalf of the petitioner. Yes. As Borua appears on behalf of the respondent number 1, 2, and 3. And Mr. Sharma appears on behalf of the health department. Upon hearing the matter, it appears that the petitioner, though while going on leave, did not inform the respondent authorities, but immediately thereupon, after coming back, had filed an application for granting him commuted leave. But the respondent authorities instead prior thereto, passed an order of putting the petitioner for treating the petitioner as on leave without pay. This court made a specific query upon the learned counsel appearing on behalf of the respondent number 1, 2, and 3 as to why the petitioner's application seeking commuted leave was not taken into consideration. The learned counsel for the state respondents sought for an accommodation in that regard. List the matter again on 22nd of May, on which date the learned counsel shall apprise this court as to why the petitioner application seeking commuted leave was not taken into consideration.
I was referred to by their hospital.
Let them come up. Leave something for the next date. No?
Item 30.
Yes, Mr. Naik. For PWD. Yes, Mr. Rahul.
My lord, here we need further 4 weeks time, my lord, to get the instructions. My lord, the thing is that this person, he has worked in so many organizations, 3, 4, 5 organizations.
Oh, that matter.
That matter, my lord. So we are
so many organizations, 6 organizations.
6 organizations. Department is also trying to connect, my lord, and that is, they said, please pray before the court that we need some time. We are trying to connect the things.
But does it take 1 year?
No, my lord. My lord, what happened?
The petition.
No, my lord.
The petition was filed on 4th of August.
Yes, my lord.
Let me fix it on 4th of August in 2023. Then I hope by that time you can get it. Is it possible then?
My lord, in 4 weeks time I will file. In 4 weeks time I am going to file it.
And Mr.
I'm representing FCI.
He
was there in the.
You are FCI.
FCI.
He was,
and health. Yes, madam. What is your status? Understood. What is your status? You are waiting for Mr. Rahul Dhar to file his affidavit, or him to file his affidavit. Why you are not filing your affidavit? What is your stand?
My lord, unless I get instructions, my lord, unless I get my instructions, my lord, my lord, the department said that pray for 4 weeks time. In the meantime, we will.
I will give you 4 weeks, but I am asking madam also. Na? Why does she want 4 weeks? You also want 4. Or you are not going to file affidavit? Why? Matter of 2022? Or is it your case that a petitioner is not entitled to? No. This is not a case where PWD department, he is there, you are there. He has worked everywhere, as he claims. Isn't it? Mr. Adhar, the learned counsel for the PWD. Miss Deborah, the learned counsel appearing on behalf of the health department. And Mr. B.K. Singh, the learned counsel appearing on behalf of the FCI. The learned counsel appearing on behalf of the said respondent submit that taking into account that the petitioner claims to have worked in various departments, some more time is required for filing their affidavits. It has, however, been mentioned that the said affidavit would be filed within a period of 4 weeks from today. Taking into account that same, let's the matter again on 12th of June. The petitioners, the said respondents shall file their affidavits by 7th of June. The petitioner, if so advised, shall file their reply in the meantime. You file your affidavits.
31.
Yes, Mr. B. Gogoi, where is he? Finance. Yes.
My lord, on 5/4/2023, my lord, the finance department sought for some accommodation, my lord. So,
Finance department has been asking for accommodation.
My lord, for
1375 to 3373. Oh, this matter I have taken today, some matter similar to that. Giving the graduate scale, na?
Graduate scale, my lord.
You come within what ambit? You are postgraduate.
My lord, I am graduate, my lord. My lord, primary school teacher, my lord.
Graduate?
Graduate teacher, my lord. The respondent authorities, my lord, they provided some assistance, my lord, they from the provincialization of the school, my lord. I am already retired, my lord.
So you want this as per that?
I am entitled for the, my lord, graduate scale.
This is as per the 95 notification?
My lord.
Oh. What is your instruction? Today I took a matter of that type. This item, I fixed it well. Item number 12 or 13, M. Doctor versus NJ Khatonia.
Yes, my lord. That is Abdul Jalil.
You are there, na?
Item 10.
You are
Item
there, na?
10, yes.
Isn't this the same type?
My
He is
lord,
claiming on the basis of that same notification.
yes. Now here what has happened, here the administrative department, my lord, they moved a proposal. My lord, earlier, my lord, to 2022, that was returned back, it was not complete with all relevant documents. Thereafter, my lord, during proceedings, my lord, as has been informed to my lord on the last occasion, 5/4/23, 5/4/23, they had moved again a proposal. That proposal was also returned, my lord, due to not insufficiency of all the documents. And a reminder was also issued to them. There is an official noting by the secretary.
Then what is to be done?
No, we'll have to examine the proposal, my lord. They will have to give the data and inputs, my lord, because all the administrative department, education department.
Yes, this school education department, Mr. P.N. Sharma, what do you have to say?
My instruction is that earlier that proposal was sent to the finance department.
The order dated 27 to 20.
Finance department says, uses the words, as such the finance PRO department by endorsement dated 28/3/2022 had requested the Department of School Education to examine the matter in detail and resubmit proposal along with relevant documents and assign proceed for further examination in the finance department. It was observed that the Department of School Education had not examined the matter properly.
And this matter will not be similar to that item 10.
It is similar, na?
No, not similar.
Why?
My lord, here, my lord, they are claiming, petitioner is claiming, my lord, on the basis of.
That 95 thing.
No, my lord, not precisely 95, my lord. Lordship may kindly come to page 20, Annex 3 of the writ petition. Page 20. This is a communication, my lord, from the government to the Director of Elementary Education. Here, my lord, it doesn't mention about that 1995.
It does not mention that. But
It will be clear from page 22, my lord. Page 22, my lord. It is of 2018, my lord. Office memorandum.
Yes, it is 2018. So therefore, that, my lord, perhaps it will not be similar to item number 10 of today's list, my lord.
Granting graduate scale.
Here, the petitioner is also claiming, my lord, the retrospective benefit.
Because I remember that this is the same scale these people are asking. 1375 to 3375.
No, Lordship is correct, but here, my lord, official correspondence shows that, my lord, they are not taking into account that 95, rather some other office memorandum.
They are taking into account the 89. 89 says about 622, 1315. That was the graduate scale.
Yes, subject to approval, the government by this office order memo number so and so dated 5 to 2018. 5 to 2018. And from the date of provincialization, so therefore, my lord, petitioner is claiming retrospective benefit. So therefore, my lord, the whole service background of the petitioner, how when he was appointed, on what terms he was appointed, and how he continued in service, what amount he has drawn for that period, everything has to be supplied from the concerned administrative department to the finance. Then only we are able to take a call.
And they have not applied their mind.
But that is what my instruction says.
Let me have the instruction.
Let me have the instruction. In fact, one reminder was also issued that there, my lord.
I've seen that. Then what do you want to do? Let's see that 89 thing once. Where is that 89? Like, you see, why I'm saying is that document of 8/3/2011, 8/3/2011, that which was the reason by which the petitioner Abdul Jalil was the case.
1811-2011.
Huh?
1811.
1811-2011. There it says that the question of giving them from intermediate to graduate does not arise because for giving a graduate scale, it has to be as per the secondary education rules. So it has to be Rule 8. These people are direct to school. However, a person who has a postgraduate, he is being given. That's an exceptional. Under 7(2)(a), Roman 2.
Perhaps because that person is having a higher qualification.
Absolutely. Yes. But otherwise, nobody is given.
Yes.
And as such, Mr. Dotto left out that argument and have now stuck to this 95 thing, where Justice Vaipai has passed an order giving them the benefit.
Now, here in this case, my lord.
And it seems this order of Justice Bhuya is also similar to the effect, similar time.
Yes, it is only, my lord, the leverage has been given to the department to consider.
But here only, but there, in that case, he said that it is entitled to.
Entitled because there was a concession.
Oh, consent.
Here there is no consent.
See the file of 11. It may give you a good case.
Otherwise, my lord, I do not find any mention in the entire pleadings and the material. Therefore, I have submitted, my lord. It is quite possible that it may not be similar to item 10, my lord. Maybe.
But the same, he is asking for the same thing.
Yes.
He is asking for the graduate scale.
Graduate scale, for the headmaster, my lord. Otherwise, my lord, the annexure 5, my lord, they have already, my lord, they did, my lord, I am entitled, my lord.
So otherwise, my lord, things will be sorted out, my lord.
Page 22.
Since the
They did not
department
deny
has
that, my lord, I am
started
not
moving, my lord.
entitled.
Since the department has started moving, lordship.
Yeah, see. Page 22, see this. See the name, Abdul Jalil.
and Abdul Jalil.
That
But I do not know.
no, see that item number 10, name of the petitioner is Abdul Jalil.
Yes, it is Abdul Jalil.
Get the point. Yeah. Hello.
Lordship will direct the department, my lord, to complete the exercise within the time. Lordship will post this matter after some time. It will be done, my lord.
Now, if this is done, then why not him?
So they are, my lord, incidentally, only they have imputed the treasury officer, not the finance department.
Where?
In Abdul Jalil.
We'll make him.
Elected Lordship.
I remember that. I fixed it on 4th.
Yes, God. Yes.
3-5.
Yes, yes.
So on that day we'll make.
My lord.
Mr. Your name?
P.K. Bhuiyan.
P.K. Bhuiyan, the learned counsel for the petitioner. Mr. P.N. Sharma appears on behalf of the Education Department. Mr. R. Borbuzari appears on behalf of the Finance Department. It has been brought to the notice of this court that the Finance Department have intimated the School Education Department that the proposals were submitted for giving upgradation to the graduate scale to the petitioner have not been properly submitted, and as such directed the School Education Department to resubmit it by giving certain more further, by furnishing further more details to that same. This aspect of the matter could be seen from an instruction issued by the Secretary to the Government of Assam, Finance PRO Department, to the Learned Standing Council of the Finance Department, which is kept on record and marked with the letter Z. So taking into account the same, let this matter again be listed on 7th of June 2023, on which date the Learned Council for the School Education Department and as well as the Finance Department shall apprise this court as regards the status of the proposal submitted.
Oblige.
35.
Yes, madam, any instructions?
Yes, we have filed our affidavit
Very
from
good.
the department.
Your affidavit is not on record. Okay, none appears on behalf of the petitioner on call. Mrs. S. Borua, the Learned Counsel appearing on behalf of the respondent, submits that an affidavit has been filed. However, the said affidavit is not on record. List the matter again on 10th of May 2023, on which date, by which date the registry is directed to place on record the affidavit so filed by the respondent.
I am for 1, 2, 4, 5, and 6.
1, 2,
42.
I am for 3 minutes.
Mr. H.K. Das appears for which device?
3 minutes. Respondent number 3,
Who is he?
Registrar General.
Why the Registrar General is a party?
Actually, in this matter, the order of the suspension order was issued pursuant to a direction issued by the additional district and session judge. So, in that context, my lord,
Okay.
Registrar
Let
General.
the affidavit.
Fine, my lord.
Mr. H.K. Das appears on behalf of the Guwahati High Court.
Highly.
Yes, Mr. Goswami, what is your case? By detailed order details as well as sought for instructions.
For instruction.
It's a long order. Oh, this. Anything has happened in the meantime? Pension, family pension of the Bharat Deputy Director.
We are yet to receive the proposal from the department, Lordship.
What proposal?
That's it.
Which department?
Perhaps I have placed this instruction, Lordship.
Madam, yo.
Yes, yes, yes.
So who should pay the interest?
Lordship, for that 50%.
In fact, there, have you seen the document?
Lordship.
They themselves say the reason why it is not being able to process because there is a delay of 7 years
Lordship.
in sending the proposal.
Lordship,
How much would you torture him?
Lordship, on May 2020, proposal was sent for pension, Your Lordship, but then it was again sent from the pension. It was returned again to us, Your Lordship, because there has been some excess royal, Your Lordship.
Then what have you done?
After Lordship, today only I have come to know about this, Your Lordship.
Then?
So, Lordship, I had asked for the instructions, but some will require some time, Your Lordship, as to what had happened after this, whether again fresh proposal was sent or not.
This document is of 15/10/2020.
2020, Your Lordship.
Then?
Lordship.
And what about the DCRG?
That proposal has to come, Lordship. Then
They have not given the proposal. Good.
Once they have sent on 19 May 2020.
Okay. Do you have any amount? Now there is an excess drawal. How much is the excess drawal?
That was not accessed,
It's
Lordship.
not accessed, Your Lordship, because it pay on so-and-so should be rupees 19,680 instead of rupees 20,190 on 1/1/2006.
Now this has been pointed out only now. Now the excess drawal, you cannot do it. How can you now initiate all this? And whose fault it is for having the wrong fixation? Mr. Gusami, I think you need to challenge this excess drawal. Or are you going to waive this?
I am already suffering, Malot. I am old, Malot. After retirement, I am no way, Malot. I am facing very much difficulty, Malot.
Do you mean that this court should go there wherever you stay out there and keep on giving unless you appear before this court?
Malot, finalize it by now.
Understood. Understood. It has not been finalized, but you see, there is a excess drawal. Now, if this excess drawal is not set aside, they are not going to do anything. How do this court set aside unless you challenge it?
Tell me. What happened, Malot? After retirement, if they found any excess, it's a meager amount, most probably due to
Not mega amount. It can't be a mega amount.
departmental authority,
When did
Malot.
you retire?
They ought to have calculated, and if it is required to be deducted from the pension due. There's no difficulty on their part, Malot. They are the mighty
This copy
government,
was
Malot.
sent to the petitioner also, Lordship.
This copy too.
This copy was.
To the petition.
Why haven't you challenged this document? Have you mentioned it in your petition?
No, well, it is marked to me, Malot. I have not received it, Malot. It is, of course, marked to me as indicated by learned counsel, Malot. But after retirement, they ignored me, Malot.
How much is the excess? Any idea? No. You have no instructions.
No instruction.
Okay.
Because today only I had come to know about it.
Very well. We'll have it on 3rd of May. Get your instructions. How much is the excess? And whether the proposal has been thereafter submitted. Have you taken it up with the finance? Because an amount above 3 lakh, it can't be waived unless there is a specific order. Below 3 lakhs, it can be waived. Why haven't you taken action to that?
Lordship, some amount has been recovered, Your Lordship.
We've recovered also. From where?
As recorded in SB
Service.
Lordship. 40,388 have been recovered with effect from 0707 to 4/2010 through pay bill.
As recorded in SB number so and so, SB, service book, rupees 40,388 has been recovered with effect from 7/7 to 4/10. Means that is for 3 years through pay bill. From the pay it has been recovered.
Because it was in his service period.
Service period. Photocopy of the Iman. He retired on so and so, but the pension papers have been submitted after the lapse of 7 years. My goodness. Heard Mr. UK Goswami, the learned counsel, appearing on behalf of the petitioner. Ms. D. Musari appears on behalf of the secondary education department. Mr. S.R. Burua appears on behalf of the director of pension. During the course of the hearing, Mr. S.R. Burua has placed before this court an order issued, a communication issued dated 15/10/2020 to the Deputy Director of Secondary Education, wherein it has been mentioned that the petitioner retired on 31/12/2012, but the pension papers were submitted on 19/12/2020 after a lapse of 7 years. Accordingly, the approval of the PNPG department, what is this PNPG? Pension
and Public Grievance
Department, relaxing Rule 205 and 206 of the Assam Service Pension Rules 1969, it was wanting. Let this matter be again listed on 3rd of May 2023, on which date the Learned Counsel for the Secondary Education Department shall apprise this court as to what action has the Secondary Education Department taken pursuant to the communication dated 15/10/2020. The copy of the communications were produced by Mr. S.R. Bolwa during the course of the hearing is kept on record and marked with the letter Y. This court also puts the Secondary Education Department, and more particularly, a Secondary Education Department, to notice as to why interest at the rate of 12% per annum should not be imposed upon the department for the delay in sending the pension papers to the Director of Pension. The Director of Secondary Education is directed to file the affidavit by 3rd of May 2023. You file your affidavit. 43. Else we will consider you have nothing to say.
I pray 4 weeks time for affidavit and instruction and it is with regard to the my compassionate allowance of a terminated employee of LIC.
Oh, this one. Life insurance. Yes. How much time?
4 weeks, my lord, because the matter has been referred to the General Office, Kolkata. It will take some.
Mr. Esnath, appearing on behalf of the respondent, submits that he requires some accommodation as the accommodation. Accordingly, let this matter be listed again on 7th of June 2023.
Right.
The respondents shall file their affidavit by 1st of June 2023 without fail.
44.
In this case, the state has to file affidavit.
May I please, Lordship? We have received an instruction, but it is not sufficient.
Mrs. S. Bulwa, the Learned Counsel, appearing on behalf of the respondent number 1, 3, 4, and 6, submits that they have received instructions, but the same are not sufficient for filing the affidavit. accordingly 6 for an accommodation. List the matter again on
Pension matter, my lord.
12th of June 2023. The affidavit be filed without fail by 6th of June 2023.
45.
My lord, here also, my lord, I have received a letter from the department, my lord. They are seeking 4 weeks time for the instructions, my lord.
Mr. Padgiri, have you approached the authorities by filing a representation in this case? Because the problem which arises is this, I'm telling you. If you don't file a representation to the Treasury Office, you are entitled to family pension. You have a particular document, the PPO has been made?
No.
No, there is no PPO.
No, no.
The person died in harness. So if you have approached the respondent authorities, have you approached the respondent authorities? No.
As per my instruction, my lord, the representative has been submitted before the my lord, authority, my lord, but no copy kept, my lord, record.
Now, during his tenure, when your husband was alive, did he submit any paper pertaining to pension?
Because my lord, he died during the course of service, my lord.
Only before the service, during the course of service, only people will give the papers. They don't give the papers after retirement.
And he ought to have retired in the year 2029, my lord. Mentioned in the regulation order, my lord, case 18.
2029.
29.
Yes, you file your affidavit when?
My lord, I have received a letter. I need 4 weeks time.
Receiving a letter for 4 weeks time doesn't make sense. We have already given you a month. A person has been suffering for the last 9, 11, 12 years.
3 weeks, my lord. 3 weeks. In 3 weeks, I will do it.
When?
3 weeks.
Heard Mr. K. Padgiri, the learned counsel, appearing on behalf of the petitioner. Mr. Adhor appears on behalf of the PWD.
No, my lord, it is sericulture.
Huh?
Sericulture, my lord.
Sericulture Department. And you are appearing?
For respondent of form.
You are filing affidavit?
Not necessary. We are the facilitator only.
Miss, you are filing affidavit?
No,
Okay. Mr. Adhor appears on behalf of the respondent of the Sericulture Department who seeks an accommodation of 3 weeks for filing the affidavit. So taking into account the same, let the matter be listed on 31st of May 2023. The affidavit be filed by 26th of May 2023.
All right.
23. Mr. B. Chakraborty appears for the A&E.
Number 65.
Oh, review petition?
Yes, sir.
Which one? For that one, where is the finance department?
Okay. This pertains to finance taxation department. That B Chaudhary and B Gogoi. Okay.
Really?
Yes.
I am.
Gogoi
Kindly allow me to call them, my lord.
His case is simple. Then look here, I was the respondent number 5 therein in the petition, and I was appointed. There was the petitioner who had challenged it. The petitioner challenged that he was the senior most as the junior assistant, so he should be given it. But this court found out that to become a junior assistant or any promotion from junior assistant, you need a degree. Now, he didn't have the degree. So not only the petitioner's petition was dismissed, but as he didn't have also the degree, his appointment was also set aside. So that is it. Now he has come up on review saying that I was not present when the court was passed the order. I don't know where he was. But anyways, he says that that was not the condition that there has to be a degree. You don't have a degree?
No.
As of now?
No.
And the degree is not necessary.
Yes, sir.
Why?
In terms of the office memorandum, it's
Oh, that one.
page 43, Lord.
Where that has not been adopted. The Finance and Taxation Department have not adopted that.
Yes.
But they have adopted the other aspects.
Yes.
Then obviously your thing should be set aside. If your is not a degree, then the petition should be allowed, don't you think so?
Lordship, but then I have annexed one.
Then it will go on the basis of seniority.
Yes, Lordship.
Then obviously your review petition should be set aside.
So page 76, Lordship, therein I have said that both of them were confirmed on the same date, Lordship. It's on.
But then also he was senior. Admittedly, he's senior. Then why should this court exercise the review? On this way or that way, your service has to go. Either I have to allow the petition, I'll review it, but allow the petition. And then give him the post against you. Or I give you keep the order as it is, thereby you get that. Now you want to do some social service, you do it.
This is a sort of a cross appeal, my lord. He is offended only by a particular portion of the judgment.
No. He says that degree is not necessary. Now you see the petitioner came up before this court challenging that, look here, he is the respondent number 5, he is junior to me. And I should be given. So on that day, Mr. B. Gogoi, who was appearing, he said that you see, you require degree. Now he also didn't have.
Yes.
So this petition, this space, he didn't have a degree.
Yes.
And when it was pointed, I put a question to him, then if he doesn't have a degree, then how do you appoint him? So he said that his appointment also should go. So accordingly, his appointment has gone. Now he has come up out here, say, look here, the degree is not necessary because that degree, that amendment has not been incorporated by the Finance and Taxation Department. Meaning thereby the degree is not necessary, which means that petition should be allowed.
Yes. So if the petition is allowed, then he will be a gift.
He's out. And if the petition is dismissed, then also he's out.
Then also he will be a gift.
But then, Lord, there were incumbents junior to be were subsequently promoted as junior assistants. There were incumbents who were subsequently.
I'm not concerned with other people. I'm concerned only with you.
Because I will come in, Lordship. If they are juniors, Lordship, I will come in automatically, Lordship.
No, the petition should be allowed. Don't you think so?
But the date of confirmation, Lordship, let them have their instructions on that. I have annexed that page 76, Lordship, regard to the date of confirmation.
He was senior to you. I remember. That was his basic case. That how the respondent number 5 has been given. He was 5. Yes, I still remember he's 5.
Yes.
Promoted to the post of junior assistant on 1/2/2018, whereas the petitioner was promoted to the post of joined the post of Chokidar as so and so, and was promotion to the next higher growth, continuous service in the remand since remand, and he has not been given any promotion. Hello, he's not there. Where are you nowadays?
Lordship, page 76.
Where are you nowadays? You lost your job.
Lordship. I didn't lose it, Lordship. I was demoted, Lordship.
Oh, very good. From the date of promotion of, oh yeah, he wanted the promotion from the date of the respondent number 5 so and so to the post of so and so. He wanted his promotion as on 1/2/2008. Anyways, Mr. B. Gogo is not there. Okay, third Mr.
I'm MP Sharma.
MP Sharma, the learned counsel appearing on behalf of the petitioner, review petitioner. Mr. Arbo Pujari appears for, you don't appear for anybody.
No, Lordship will record my name, my lord.
How? You are nobody?
Otherwise, it will go unrepresented.
Okay, none appears. Where's your review petition? Who are the parties?
Lordship at page 2, 3 and 4.
Hello. We'll have it on some other day.
My lord.
And none appears on behalf of the Finance and Taxation Department of the Government of Assam. Taking into account the same, let the matter be listed again on 8th of May 2023.
Okay.
66.
What? Yes,
My
madam.
lord, in this case, already affidavit has been submitted. Justice service has already been completed, and affidavit has been submitted. And the response number 4 and 5 have also submitted, my lord, affidavit in copy.
Yes.
Hello, I have also received instruction, my lord. So I need to put it on record.
Why?
My lord, that is the only reason, my lord. During that time, my lord, she was working two different institutions. That is why.
For that doing.
Yes, my lord. She is working in a venture school, my lord, and in the as a contractual teacher in the high school, my lord.
So she was getting 2 salaries.
Yes, my lord.
No.
You're getting 2 salaries.
That is our stand, my lord.
No, no, you can't have a stand. Obviously, you have to have a proof. And proof of 2 salaries has to be from a particular account.
That proof, in fact, in the instruction, that proof, they have not given that proof, my
No,
lord.
no, that is the most important thing.
Yes, my lord.
A person may voluntarily work in another school,
Yes, my lord.
which your, and more particularly your school department allows anybody to work anywhere, whether it's provincialized, government school, everything, which you don't find in private schools. Anybody can walk into the school and work. So that she can very well work. But is it okay that have you paid him her 2 salaries?
That information in the
If it is
instruction-
not so, then what is your problem?
Yes, ma'am. That information is not.
And if you don't want her
incorporated in the
service, she wants, if she is rendering 2 services for the pay of 1, you'll be happy. Isn't it, man?
In fact, my lord, no salary was paid, my lord.
Huh?
No salary was paid.
Then, if no salary is paid, where is the question of the petitioner's salary being stopped? You don't want her? Ask her to stop. Don't worry. She won't go there.
Yes.
But you can stop her salary for that. When? We'll have it on Wednesday.
Yes, madam.
Get that only instruction as to whether there are 2 payments. If it is 2 payments, then obviously this court will think about it.
Yes.
Otherwise, the question of not paying her salary does not arise. And you have not got 2 salaries, no?
No, my lord.
Okay.
Certificates also there, my lord.
Huh?
Annexure 5, my lord. Kindly see.
Then it's
Annexure
okay.
5.
It's okay. Heard Miss N.S. Sakuria, the learned counsel appearing on behalf of the petitioner. Mr. N.J. Khatonia appears on behalf of the respondent number 1, 2, and 3. And Mr. Day, you are appearing for?
4 and 5.
Mr. Rupjit Day appears on behalf of the respondent number 4 and 5. Your instruction is there's nothing.
No, nothing.
You are filing an affidavit?
I have already filed.
Okay, you have filed an affidavit. Okay. Upon hearing the matter, this court have inquired with the learned counsel appearing on behalf of the, what is this school? Higher education?
My lord,
You are appearing for which? Secondary Education Department as to whether the petitioner was getting two salaries from the State Department. The Learned Counsel, Mr. N.J. Khatunia, submits that he will inquire into the same. On the other hand, Mr. R.D., the Learned Counsel, appearing on behalf of the respondent number 4 and 5, has submitted that they have already filed an affidavit, wherein it has been mentioned that that when the petitioner joined the high school at that time the higher secondary section was in venture stage, and there was no teacher in political science department, for which the students of class 11 and 12 had suffered. As the petitioner is a master degree holder in political science, the school managing committee in its meeting held on 12/10/2010 temporarily appointed the petitioner on honorary basis by resolution date number 7. It was also mentioned that the petitioner had taken classes of class 11 and 12 by adjusting her own classes in high school section, and as a result of which there was no negligence on the part of her. Full stop. You have not got your salary from 27/12?
My lord.
You have not got your salary from 27/12/2021?
Yes, from August.
You have not got your salary, no?
Yes.
Taking into account that the petitioner have not received the salary from 27/12/2021, this court fixes the matter on 3rd of May 2023, on which date the Learning Council for the School Education, Secondary Education Department shall apprise this court as regards the queries so made. Liberty is given to the petitioner to mention the matter for upgrade.
Only thing is salary from has been withheld from August 21.
Huh?
Salary
From August 21.
Not 27.
From August 2021.
August 21.
27 to no, August 2021.
Obliged.
Very good. Any urgent matters? Yes.
I have got a review petition, my lord, item number 46 and 47.
Take it.
Already person has been expired, my lord. Nothing has remained in the case.
Huh?
Review petition, my lord. Firstly, they have filed a petition, my lord, against my order, my lord. That order was passed in 2019, my lord.
Very well. Review.
Yes, sir.
There are two cases, my lord. First, they filed a petition, my lord.
Let us see what is this review business.
My
Yes,
lord,
what review? A review against whose order?
My lord, Honorable Justice N. Singh, my lord.
Oh, you filed immediately he left?
Yes, sir.
Or did you file before that?
Before that it was filed, my lord, but
Then why did this come before the court?
it was not finally disposed.
He only left recently.
Yes, sir. But what happened, my lord? They have prepared a writ petition.
Huh?
They have the private respondent had prepared a writ petition, my lord.
Okay.
And that writ petition, I during the proceedings of the writ petition, I was not able to appear before this court, my lord, and I could not due to my illness. Illness means kidney failure, so I could not contest with the writ petition, my lord. And thereafter, I approached this honorable court in the review petition, my lord. Court
has the review notice has been issued?
Yes, notice issued. The government has filed their affidavit also, my lord.
Okay, what is the review asking for? Why are you seeking review?
Yes, lordship. The honorable court, my lord, may I take a lordship to page number 84, my lord, directly.
84.
Yes, lordship. What happened, my lord? This honorable
Your name is what? Vijay Kumar, Vijay Shankar Thakur?
Yes, lordship.
That order is passed by Justice Bujal Borua.
That is, my lord. Subsequently, I filed the writ petition, page number 84, my lord.
No. Which is the order of review?
Order of review, my lord. Page 82. It starts from page 82.
Page
82. review
80?
82.
Page 82.
8/2019, my lord, in WPC number 3386/2018.
No, in the review petition.
Yes, sir.
Okay, now what is this order? Tell me.
This order, my lord, my appointment has been interfered. Appointment as my as provincial teacher, my lord.
Why?
On the honorable court held that I was junior to the writ petitioner, but in fact, my lord, I am senior to the writ petitioner, my lord. Date of when the date of joining of the two persons are same, my lord, then the seniority is determined on the basis of date of birth, my lord.
Impugn order dated by which the provincialization of the petitioner's service have been withdrawn, set aside, with the direction the petitioner be provincialized in lieu of respond number 8. You are respond number 8.
In the writ petition.
However, since it is submitted that the vacancies as arranged in the meantime in the post of assistant teacher in the state school upon expiry of 2 of the provincialized assistant teachers, namely students of the representative who had been provincialized and working here, may be adjusted against one of the aforesaid vacancies. However, since the petitioner was senior and has a better claim for provincialization as assistant arts, but was wrongly provincialized as Sanskrit, which have been admitted by the respondent authorities themselves, it will be deemed that the petitioner's service be provincialized with effect from Iman in terms with the order dated month of the responsibility. Insofar as the claim for payment of area is not release the same in it. Now tell me, what is wrong with the order?
My lord, in this writ petition order, my lord, I was held junior because, my lord, I was not able to present myself. But I was not heard, my lord. In that
No, not hearing you is a different thing. I'm not concerned. Is it the fact that the notice was not served upon?
Yes, notice was served, my lord. But
the notice was served, not being heard is not a question of review. But why are you asking that the review should be?
My lord, in this writ petition, my lord, page number 84, my lord, order.
No, you say, are you senior to him?
Yes, sir.
Show me how.
Yes, sir. When the date of joining is same of two incumbents, my lord, then the seniority is determined on the basis of date of birth. And I am by senior by date of birth. Therefore, I am senior to him, my lord. And this has been observed while we have challenged in the writ petition the consequential order passed by the department on the basis of the writ petition's order, my lord. We have filed the writ petition. And in that writ petition, your lordship will find that was observed by that we have to file the review petition. Therefore, we have filed this review petition, my lord. While in page 90, my lord, paragraph 9, it is.
Now you are senior.
Yes, sir.
On the basis of the date of birth.
Date of birth.
Both of you joined together.
Same date.
And it was not brought to the attention of this court.
Yes, sir.
That is your case.
That is the main case.
Yes, Mr. Are you senior? Are you senior to him?
Yes, 5 minutes prior to his joining, my lord, I joined. And on that day, my lord, when I joined, my lord, and 5 minutes later he joined, my lord. But thing is this, my lord, when there is an undertaking of the teachers, my lord, regarding preparing of gradation list, my lord, it was made by the headmaster of the school, my lord. Then he said that I do not have any claim. Whatever the gradation list has been prepared by the headmaster will comply with. That undertaking was given by him.
No, Mr. Chetri, whatever he does,
Number one,
I'm not on that. I'm asking you, are you senior to him?
That 5 minutes, my lord, that 5 minutes only.
When a person joins on the same day, how would the seniority is reckoned? Is it on the basis of the date of birth?
Yes, date of birth, my lord, subsequently it will come, my lord, if the same date of birth is, same date of joining is there, then date of birth will come. But since he has not claimed on this issue, my lord, for a long time, and even in 2018, from 2018, though notice was served to him, my lord, and accordingly, he did not contest the case, my lord. And since in the all communication of the government, all communication of the schools, my lord, it was
no. The finding of the court,
yes,
that you were senior to him, is based arrived at what?
No, finding it was not the case of the seniority, my lord. It was the case, my lord, since I was the assistant teacher, my lord, on the basis of the chart made by the government, my lord. I was put my name, my name was put at serial number 3, my lord, as assistant teacher. But subsequently, when the school, my service was provincialized, the school was provincialized, my lord, my post has been put as Hindi teacher. Sanskrit teacher. And against that, my lord, and in the Hindi schools, this Sanskrit teacher cannot be continued. No. Subsequently, it was again this in the forwarding report they have said Hindi teacher, and subsequently in the provincialized order it has been Sanskrit teacher. Then I have come before the honorable court. Since there was a communication that I was not a Hindi teacher, I was not a Sanskrit teacher, I was an assistant teacher. That has to be corrected, and government level also it was corrected. But my case has not been considered. And against that order, that Sanskrit teacher was also withdrawn, my lord, subsequently in 2015, that post.
Understood. But why have you made the respond number 8 a party?
My lord, he has been put before me, my lord,
so what was your grievance that he was put before you?
My lord,
why were you agreed?
Since he was in the 4th position as per the list prepared by the government and the school authority, my lord. But he has been put, he has been given the assistant teacher, but I have been given the Sanskrit teacher.
Was he a Sanskrit teacher?
No, he was not the Sanskrit teacher.
Why are you agreed that he was put at serial number 4?
No, the post which was supposed to be given to me, my lord, at grade 3 post as an assistant teacher, but that post has been offered to him, my lord.
Why?
Since I've been preferred the Sanskrit teacher, my lord. So Sanskrit teacher, subsequently again they have withdrawn, my lord. I got the salary for about 1.5 years, my lord. Then Sanskrit teacher they have withdrawn. Government has withdrawn. That saying that the Sanskrit teacher was another person. So you are no longer in the post. And the Sanskrit teacher, he has been given the Sanskrit teacher, my lord. Another person was there. Against that, my lord, I have come before lodge.
Understood. But why are you against the respond number 8 in this petition or the here?
Since there are only 3 numbers of assistant teachers, my lord, in the school. So he was given that the post assistant teacher, my lord, ignoring my claim, my lord. That is why. And subsequently, my lord, since there were 2 posts lying vacant, my lord, and to that extent, that information was furnished before the court. Court was pleased to direct the respondent authority to accommodate him in the post, my lord.
Yes, junior. The basic reason why the court here is that he's junior. But is he junior as per the established principle of law? Is he junior? If a person joins on the same day, which is what is being taken, yes, Mr. Katanya, you are the government.
I find my affidavit, my lord.
Yeah, what is your stand?
That is the stand.
If a
taken by the
person,
review.
2 persons joins on the same date,
now only
how do you regard the seniority?
Date of birth, my lord.
Only
He's senior.
Only
Then-
that.
I have admitted in my affidavit, my lord, he is senior.
But only now, my lord, what the situation in the school is this, my lord. Only one teacher. This the Lokman Ansari is already in the school, my lord. Others are already retired and some are dead. Only one teacher is running the school, my lord. This is the problem is going on. And
And
already,
what
the
is the
review
government
petition
doing?
already been expired, my lord.
Huh?
Already been, the review petition already been expired, my lord. Nothing will remain, my lord.
Right?
Yes.
They substituted by the wife and the sons, my lord. That's
For
it.
what?
For pensionary benefits, all this, my lord.
Nothing will remain, my lord.
On the pension? Is he not entitled to pension?
That part is different, my lord.
No, obviously, if he's no job, no pension.
No, since he was there are also some of the this honorable court's decision, my lord. Since he had to come before this honorable court at the relevant time, he has not come, and he was all along sleeping for 3 years or 4 years like this, my lord. Now he has wake up and saying that no.
No, he has filed a review. At that point of time, court issued notice.
Yes, notice was served, and accordingly, personally it was served, and it was.
No. When he filed review, who filed review?
I filed.
In 21.
He was alive at that point of time.
Yes.
No.
When he filed the review, he was alive.
Yes.
He was alive, and subsequently he has expired. Now, only the point remains, my lord, since.
Now, Mr. Prakash, if I review this order,
yes.
What happens to the petition? This person?
His my lord, provincialization will go, my lord.
Why? There is no vacancy.
Now there is vacancy, but the question is that whether once the post has been vacated, retired by some, expired by someone, my lord, that the post has to be filled up through regular selection process. That is the established law, my lord. Now, if your lordship can give direction, special direction for his accommodation against any vacant post, then of course there is exception. But otherwise, once the post is deemed to be vacated, it has to be filled up through regular.
No,
but it has been recorded in this order that you are to be accommodated against some vacant post.
That is the while complying the order, my lord, they have taken into consideration that I could not be accommodated because it is not permissible under the law.
My lord, that part may be considered, my lord, since this honorable court has also passed the order to accommodate him, my lord, in any against the existing vacant post, my lord. That on that particular issue, in earlier occasion, also court given the stress and requested the government advocate to consider that aspect, that since both party will otherwise survive, because already out of 3 assistant.
Why is this matter before this court?
That part
I am not a person who normally is very kind towards sympathies.
No, that order is there, man. That is
understood. For that, whoever it is, that such orders should be before those courts. I am actually nothing to do with sympathy. But the only thing, how can it be worked out? It is a balance between a person's pension, a family's pension, and vis-a-vis a person's job.
now.
And what is your age?
Now I'm also will be retired, my lord, within short time. Hardly 2 years or 3 years.
And you have worked for how much? 2 years.
My lord.
When was this order passed?
This order was passed in 2019, my lord.
So you have only worked for 2 years. 3 years.
No. I was working since 1990, my lord. And provincialized was done in 2013, my lord. And I was continually working, my lord.
Because unless I set a review this, the question of he getting the salary doesn't, the pension does not arise.
But otherwise,
and if I review this, your right is gone.
Yes.
How do you have a midway in between?
In between,
unless you go into the principle where the pension is being divided amongst the Muslim widows.
Since, my lord, there is a court's order, my lord.
Court's order is there, but that is the order which this court, he has asked for review.
So in that case also, this honorable court was earlier occasion, my lord. This honorable court was pleased to request the government council to consider and
Which court?
earlier court number 2. Earlier court number 2, the matter was listed. before
Then
the
you
court
have
number
to
2.
now go to
It was
Jammu and Kashmir.
either way, the persons will be deprived.
Any other considerate judge, let me place it before him. Because this is not the case, only because the problem is this. For you to get salary, you have to be appointed properly. Now, another perspective, if you are being appointed, just think about it. If you are being appointed now, then can your past service be taken into account for your pension?
No, that has been already been mentioned, my lord, by the honorable court.
What?
That order was given.
Who? That order by Justice Koteswar Singh? Huh. That order which goes. That order is based on a wrong premise. The government should have pointed out that the senior was him.
No,
It is only on the basis that he is junior to you, the court has passed the order. But the fact is wrong. The government should have at that point of time pointed out that when two persons have joined together, it is taken on the basis of date of birth and he had joined together. Whether he is represented or not, it is for the government to point it out. The government shouldn't have been silent at that point of time.
So,
Yes, my lord.
Hmm?
It is wrong in the part of the government.
It was necessary for the government to point out that.
probably that all this.
In fact, that most probably the government didn't have the instruction that both of them. But you knew about it, that both of you joined together. How did the court come to a finding that he is junior to you? If the government didn't have instructions, it is you who must have told him.
No, on that point of time, my lord, only the question was arise, my lord, regarding withdrawal of my the service as Sanskrit teacher.
Understood. The court shouldn't have gone beyond that then. That's holding that he is junior.
No,
And that is the reason, if you see here, having gone through this, kindly see paragraph 7. Only basis the court has passed the order is because he is junior. And how did the court come to know about this?
No, some documents were there, man.
Having gone through the records, this court is satisfied that the petitioner has been wrongly provincialized as so-and-so. Till there, it's okay. The letter dated issued by Under Secretary to the Government of Assam clearly mentioned the name of the petitioner as serial number Riman and the name of the person who have been wrongly provincialized as so-and-so has been shown as junior to the petitioner in the said list prepared by the authorities. If the competent authority contends that there cannot be 4 teachers and only 3 teachers, the said so-and-so has to be replaced by the who is higher in seniority list.
My lord, thing is very clear, my lord. Since there is a gradation list prepared by the.
Have you challenged Mr. Purkas to the seniority list?
No.
Seniority list, my lord, it is shown that I am senior, my lord. It's there. It is there, my lord.
Where?
I am saying, my lord.
Yes,
page 53, my lord.
Page?
53.
No, then how did the court come into that finding?
Court has come to because page 79.
No, page 53.
53, I think.
Page 53, yes. Your name is what?
I am at serial number 7.
7.
My
Lukman
date of birth-
Ansari. And he is Bijay Shankar.
Yes.
Okay, and date of birth? He is 60. Oh, no. Wait. You are younger.
Yes.
Your date of birth is 5166.
Wrongly given.
Huh? His is 1765. Then?
No, my lord. This is recorded.
Huh? The entire case takes a somersault.
They have given.
Huh? Page 71.
Page 53, my lord.
53 only I am seeing there.
Vijay Shankar Thakur is date of birth 1/7/1965.
The date of birth is my lord 31/7/1965.
How is it? This page 55 also says the same.
Page 93, my lord.
Page 55. Bijoy Shankar's date of birth is 7/17/65. And you are Ansari. Are you Ansari?
Yes.
No.
Vijay Shankar.
Oh, you are number 8. You have been put at below. You have put at serial number 8. You have put at serial number 8, not 7. He is Ansari.
Yes.
And what you are showing, page 73.
79, my lord.
The court was persuaded on the basis of this.
Yes,
Page
79, my lord.
79. Yes,
This is a misleading letter issued by the headmaster, my lord.
on the basis of all available
Paragraph second.
records in the email that man is the third graduate teacher and he's senior to Bijoy Shankar. Oh, it is because of this letter.
Yes, sir. The time is given 7:45 and 7:50.
On the basis of this 5 minutes. The
Yes,
5
sir.
minutes has no business.
No business, yes. Sir.
Chalo, we'll hear it again. Think about what can be the biomedia solution. Otherwise,
There is one more difficulty, my lord. This provincialization was done under the 2011 Act. Actually, the Act was struck down.
so
My lord, now, at this stage, my lord, it's very difficult to find out a midway, my lord.
no.
Any concern
If a
has to-
provincialization is done under the 2011 Act, and there is something wrong in doing it, whereby it violates the mandate of Article 14 or 16, not on the basis of the provision,
Yes.
but on the basis of a violation to the fundamental rights, then obviously it can be set aside without touching on the provisions. We are not concerned with the provisions.
That I understand.
Now, by virtue of Section 24 of the 2017 Act, wouldn't that be saved?
That can be said, but regarding accommodation of the another person,
That is the problem.
That will be difficult, madam. That is-
When? How many more days you want to work?
And since this phase 49, all this, my lord, the letter was communicated. He has given the undertaking saying that I do not have any emergency. Then, my lord, since 2013, he was sleeping.
No. Who has produced those documents?
My lord, these documents, my lord, he has.
You
the
produced at the time of hearing in the writ petition.
Yes.
That means you showed it before the court
Yes.
that he was junior to you and he has accepted it.
No, all these official documents, not my documents. Official documents.
Official documents, how it was brought to the court.
By virtue of the writ petition, my lord.
So that is what the petitioner had produced it.
Yes. And
So why didn't you point out the rule that if the date of joining is the same, it is on the basis of date of birth?
no, since
If that is the rule, you have to apply that rule.
no, since that time, my lord,
The rule was not there.
the core issue was, my lord, regarding my this
Sanskrit.
Sanskrit, my lord.
So the court shouldn't have gone there.
No, that part, my lord, whatever the government's communication were there, his letter, my lord, that regarding seniority, my lord. This seniority, no objection of teachers regarding seniority. It was written by the teachers, my lord, to the inspector of schools. Sir, with due respect, we have the honor to state that that we have not any objection. We have no objection regarding the seniority list prepared by our headmistress. This is for favor of your kind information necessary action. This letter was issued.
Is this a document which is required to be sent in terms with the statute? No. The 2011 Act, neither the rules stipulate that. This is only being done by the headmistress because a lot of fight is being ensured that you have put me senior, that was
This 8 numbers of teachers they sign, my lord.
maybe that
8
is
numbers.
okay. But would you say that that to be a relinquishment or any, because his right is under Article 14?
No.
Can it be waived?
My only prayer will be, my lord, since he has not come in time. Had there been in time, my lord, certainly he has the case.
He had a kidney problem.
Yes, he has expired.
And since 2013, my lord, he has not come before this court. He has accepted. Now, after passing the order, he has wake up and saying, no, I was the senior most person. I have not been. Had it been raised since he has been made party, had it been raised this question, then certainly this order would have been something different. But he has not come. And now...
No, tell me, if he was present and he had pointed out that, look here, I am senior by virtue of this rule, would the court have said that he is junior?
No.
That
That
is the question.
Every there is a settled position.
Anyways, think about it. Ponder what to be done. How do you save yourself? We'll have it on when?
After 2 weeks.
2 weeks. Okay, we'll have it on. We'll dispose it of on that day.
And in meanwhile, my lord, lordship may consider that aspect, my lord, since there is also no teacher, my lord.
There is
Only
no
this-
CAV.
This petition.
I am not going to consider now because it is not CAV.
No,
I will only see the
I'm
file
not
when
on
the
that, my
matter
lord.
comes.
Only I'm just appraising before Lord.
No, it's okay. But I am allowing those great minds on the other side to think to how to take away of the situation. We'll have it on 15th at 2 p.m. I'll pass the order on that day. Yeah. Chala. Yes, Mr.
Little accommodation, item 37.
Yes.
That's a matter when she came before the court, and on the ground that she came before the court, a suspension order was passed. She's a professor at a law college. This matter is already ready for hearing. If I may ask for an early date, because she's suspended. There were 2 cases. She came because she was removed from the post of secretary of Tezpur Law College. Then she.
Oh, that matter?
Yes, madam.
Yes,
That Smita Deka. So today it was fixed. Can I have it on 3rd? Can your lordship fix it? Because we are
No, I can fix it up. But the only thing is, whenever I pick up the matter, last time I wanted to dispose of the matter, you said that no, not today, you are not prepared. That is why this matter has happened.
Because they wanted some accommodation.
No, last time it was you.
No, I was not, because
I specifically asked you. Today I was about to dispose of the matter on that last occasion. You only said that the matter was urgent. You have said, I still remember what it was your argument. Your argument was on Pratap Singh, malice in law.
Yes. No,
I specifically asked you, whether you did come under, you said malice in fact. I said, would it not come under malice in law? I remember that.
That day time was sought from the other side.
No, they didn't say. You sought for the time. You wanted some accommodation to file a reply to the affidavit. Isn't that?
Yes, my lord.
I remember.
Reply
She
has been
appears for
filed.
response number 8.
5, my lord. The
5 or yes, some
reply was filed on the day, on the last day itself.
Yes, when do you want it?
My lord, can it be?
But that day you have to finish it off.
Yes, I am ready.
Because these suspension matters, I don't take them much time. These are suspension, pension, all these are all Monday, Wednesday, and Friday matters.
Yes, sir.
But anyways, you want to do it? You want to finish up? On we'll have it on 2nd.
Yes.
2nd. Well, we'll take it up on 2nd.
Apply.